Okay. Okay. All right. We had started without the video, but we have the audio. And once again, this is the regularly scheduled meeting of the Ethics Commission for August 28th, 2017. We have called the roll and everyone is present, including our newest member, Commissioner Yvonne Lee, who was appointed by Mayor Ed Lee. Commissioner Kopp and I were at her swearing in this afternoon. So we'd like to welcome you to our commission. We look forward to working with you. Commissioner Lee has a long history of many things relating to San Francisco government. She was also on the police commission, other areas of San Francisco government, and she's been a very productive person, and we look forward to being the beneficiary of that productivity as having her as our fifth member. So with that, we'll begin with agenda item number 2, public comment on matters appearing or not appearing on the agenda.
Good afternoon, Commissioners. It's Charlie Marsteller with Friends of Ethics. I did have some items I can throw in the overhead projector for the viewers on television. Are they with us today? We are on TV. Okay. Not that I want to be on fake. So I'm putting that on. How does this work? And you can make adjustments as you need to. Maybe, or just I think it's doing, oh, that's pretty good. Perfect. I recently had an occasion to redo the Common Cause archives. Our archivist finally died at the age of 95, but she'd been busy 20 years clipping stories. She was an avid reader, and she did a lot of excellent work. So we now have those files available at City Archives, and they soon will be on public view. But we've prepared a user guide of 25 pages, and we've submitted it to the commission staff so that they can use it, especially for investigation purposes. It was our own investigative files, along with a bunch of tremendous press items. I did want to also say that we had a number of things that impacted me as I was going through them, and 2 items came up as a metaphor for the changes of what I have seen at this commission since I've started regularly attending meetings in 1997. And I think all of us realize that the city has changed. The big example, in this one case, a visual example, is this item off of San Francisco Magazine, which shows the Skidmore-Owings mural model that was prepared in the early 2000s. So there were, oh, I'm sorry, we're out of time, but I'll make it quick. This was clearly some visionaries at work, and I think there were a lot of people working on the future of the city that most of the people in the city were not so aware of. I think they began to realize what was going on with the Rincon 1 abutting the freeway. That was the first time I think a lot of people realized that something was going to happen south of Market. The last thing I wanted to mention was, as a metaphor, there was a money flow chart that was distributed by San Francisco Magazine as well. As you know, we're running out of investigative press, so there's not a lot these days that's getting covered, but this showed this one individual in the city and how many activities he had been undertaking on behalf of basically city interests. And they raised the question as to what all this might be about. And I'm distributing a copy of this in more detail to the commission so you can see why the question was raised. But these two things really serve to me as a metaphor as to why there are elements in our bill that's pending tonight before the commission that discusses things we've never discussed before or furthers issues that we've been discussing and are concerned about, because the city has changed, and I think this commission has started to meet its challenge and keep pace. I think there's obviously a need, because I did want to mention on this first visualization on the screen showing downtown south of Market, there was some discussion as to the population of the city, which is projected to go to 2 million permanent residents, in addition to the daytime population, which surges for downtown employment, as you know. That's my only point.
May I ask a question, Mr. Chairman?
Certainly. Commissioner Kopp.
I want to be sure I understand the chart you've distributed, in which there are copies available to the public. Who is the maker of the chart?
It's given on the upper point here, the infographic by Margot Trudell,
right.
San Francisco Magazine. And this is the magazine here.
I know the magazine.
Oh, very good.
And that means this has been published.
It's been published in 2012, I believe, if I remember the date right. It's got a memorable picture on the front cover, which shows the late, great Rose Pack.
Thank you.
You're welcome.
Further public comment on matters appearing or not appearing on the agenda?
Good evening, commissioners and audience and listening audience. My name is Ace, better known as Ace on the Case. I am here today just to witness how crucial and how important this commission is to the city and county as far as fair government. I'm also here to express a couple of my concerns. On one hand, as an African-American, as the czar to out-migration, so I'll strike that name as African-American, as a black man. And also here to talk about the city government and all of its corruption and all of this pollution. Well, I have a solution to all that. It's about legislation. I'm saying this to my supervisor. Legislation, conversation about legislation. I just want to thank this agency. I've been down to your office a couple of times and spoke to one of your investigators about an agency in which I'll speak on a little bit later. But I come with a number of agencies that need to be checked. But one of them specifically is the Human Rights Commission. I mean, it was set up for human rights. And if you want to go a little deeper, it was set up for the rights of the blacks that was up and down the Van Ness. So I won't go into that history unless you want me to, but I don't have those minutes. But not only just the Human Rights Commission, we got OEWD, OCII, the Department of Public Works. All of these agencies are basically ran under the mayor. So therefore, I don't have to point the fingers at the directors. It's the mayor's responsibility. He has different individuals that are playing dual roles as executive directors of agencies. For instance, let's say OCII, OEWD, and the Housing Authority have a dual role. But I'll get into that a little bit later. I got to get calm and cool and collective here. I also noticed in the paper, and I'm here to speak on Fillmore, there's a lot of corruption in the Fillmore. And people of my color that I know for over 20 years. I need not name them, but I will. The Derek Butler, the Keith Jackson, the Human Rights Commission, Zola. I know all those individuals as an activist over 20, 30 years in my community. So I am just like you, trying to put some kind of stability in my community. Also in city government. But see, I don't have the power nor the staff that you have. I'm just one individual, and with the help of God. But with this agency, maybe I could forward my determination in my community. And I'm not pointing fingers at my queen bee, who happens to be the president of the Board of Supervisors, which is a powerful position. And I shouldn't have to go through a lot of things I have to go through, but politics are full of tricks, makes you turn to a lunatic. And I know that. And sometimes you might get, I'm not going to say that. But, ladies and gentlemen, I'm here, and I'm glad that we have this agency alive. My name is Ace, and I'm on the case today.
Thank you. And any further public comment on matters appearing or not appearing on the agenda? All right, we'll then go to item 3, discussion and possible action on the draft minutes for the Commission's June 26, 2017 regular meeting. Do we have any additions or comments upon the minutes of that meeting, Commissioners?
Mrs. Chair, since this is my first meeting, I wish to recuse myself from voting on the approval of the minutes since I wasn't there.
Yes, Commissioner Lee is making a request that is the same request that I made when I first came on, and that is since she was just appointed today, she's not been able to familiarize herself with the matters that are before us on the commission. We have a strange rule on this commission, though, and that is that the commissioners cannot abstain from voting, which is, I remember, what I first asked to do. But if they feel that it would be improper for them to vote on an issue because they don't have enough information, they can ask to be recused on those matters. So what Commissioner Lee is asking is whether or not the commission will recuse her from voting on the particular matters that, as they come up tonight. And I think since she's indicated she wants to do this on all of them, rather than go through each one, perhaps if there's no objection, we can take the matter now and vote on whether or not Commissioner Lee can be recused from voting on these particular matters. So without...
Mr. Chairman, I'd move to recuse Commissioner Lee from voting on item 3.
On item 3, so we'll take them one at a time. Is there a second to the motion?
I'll second.
Second.
Okay. We'll then call the roll. Vice Chair Chu,
Aye.
Commissioner Rennie,
Aye.
Commissioner Kopp,
Aye.
and I vote aye. So Commissioner Lee is recused from voting on item 3, and we'll keep going as any kind of vote action comes up on any of the others. So what do we have, with that in mind?
I'll move approval of the minutes.
All right, is there a second?
I'll second.
Second.
Okay, all those in favor of approving the minutes?
Aye.
Aye.
Okay, the minutes are approved.
Don't we need public?
Oh, we have to have public comment, excuse me. Any public comment on the minutes? Oh, hearing none, then the minutes are approved. We go now to item number 4, discussion and possible action on the Ethics Commission Annual Policy Plan as revised for fiscal years 17 and 18 and presented in the staff policy report. There's an attachment of August 24th, 2017 of the staff report and attachments. So we'll hear from Kyle Kunder on that item there. Kyle.
Thank you, Commissioners. So I do have a PowerPoint here today, and hopefully all of you, public has, yes, because obviously it's very blurry, so hopefully everyone got a copy of this. But so item 4 here is an update using a policy report. We're sort of reviewing what was the annual policy plan and a couple other tracking documents. But I want to start out sort of taking you through, as we've sort of developed a policy division in the commission, how we plan on sort of taking these items through the normal policy process going forward. So having your slides handy there, you sort of see the first slide here sort of takes us through what is the annual policy plan? And that's sort of our outreach document, our outward facing. It's the broad scale sort of projects that we're working on. For instance, CFRO revision and review that we embarked on this year. And you see that that's sort of a macro level plan. It's something for the public to view. It's something for you guys to see that's hopefully simple and sort of allows you to set out a general timeline or framework, if you will. It's something that we can modify when need be. And just again, so it's if you turn to page 2 of your slides, you see sort of what our sample annual policy plan we plan to look like. A little bit modified before. We tried to clean it up a little bit. But again, you see this sort of the subject matter areas that the commission deals with and the sort of timeline and tentative timeline of items and how we sort of plan those to look going forward. So in addition to this document, we've sort of taken a view that the annual policy plan wasn't enough, didn't provide enough accountability and transparency for both us as the commission and staff, and enough for the public. So we've developed what we are calling an initiative tracker. And that initiative tracker, if you turn to page 3 of your slides, you sort of see what a sample will look like here on the right, and then the items on the left sort of explain what this is. This is sort of meant to break down the large-scale items on the annual policy plan into the initiative tracker in the form of a Word document and explaining each item in detail, explaining the project timeline or tentative project timeline, explaining these sort of implementation projects that get us to a final answer. It provides the public and us a little more detail of the items that we're hoping to take forward, and it hopefully provides some background to people who are coming in new to the commission's sort of policies and projects. And then going down the line sort of a step further, you see as we move down, we're getting smaller scale, more detail, micro level, and they become less fluid at that point. We sort of have to set these things in stone as we move down the line of these items. But if you switch to slide 4, you'll see what is a sample project plan and what those what sort of a simplified project plan will potentially look like here. So, you know, we use the public financing review project sort of just as a sample here. But you see we sort of take policy level review, staff level review, in addition to that period covering interested persons meetings, private meetings with the regulated community, and then taking further outside input from subject matter experts and so on and so forth. So we're trying to formalize this process a little more for our staff so we have an understanding of what the sort of timeline, what the project dates are, and this specifically breaks it down into sort of subject matter areas. We are embarking on the use of task force teams, ensuring that every division gets their hands on our larger policy things so we can ensure that the policy division reviews, enforcement helps us review legal aspects. We address administrative feasibility in terms of electronic disclosure and other things like that. And then so that sort of those project plans that hopefully lead to a, potentially a modification of an ordinance, a regulation, or just a general policy statement. Again, as we move down the line, they become less fluid, but these items are all meant to sort of just inform our procedures a bit more than simply having an annual policy plan with these sort of, I don't want to say arbitrary, but maybe a bit amorphous items. The sort of, if we say CFRO revision and review, we don't really know what that is unless that's explained a little bit further, and that's meant to sort of hopefully increase the public's knowledge of the ongoings at the commission and hopefully give a little more background and detail to those projects. So with that, I can open it up to any questions or thoughts you guys have about the sort of documents we're going to be presenting, obviously more formally as we go along. We'll plan on using the initiative tracker, which is the sample on your third slide there. Going forward, instead of a policy report, we'll try to bring this a little larger document that has this larger explanation in place, and that'll sort of supplant what is the policy report. and we'll just highlight the key tones. We won't obviously go through every single policy, every commission meeting. That's a bit of overkill, but we will explain sort of ongoing projects and where we are in the timeline of those items with these things. So with that, I'll open it up for any questions or thoughts on these items or the policy plan in general, or what you think about our sort of thoughts on our policy sort of team going forward.
Thank you, Mr. Kundert. Commissioners, any comments or thoughts? Yes, Commissioner Chu.
Mr. Kundert, I think this is an excellent approach to policy and provides a lot of information and accountability, both for the commission, the public, and the commissioners as well. And I do laud you and your team for putting the effort, the hard work into creating something like this. I know that it is not easy. It looks very clean and simple and easy to follow here on the page, but I know that the process itself was probably like making sausage. So thank you for the work on that. I think this will be an excellent addition to our monthly meetings and give us a much better view, both at the high level, 20,000 feet, and at the granular level on project details that will be very helpful for us. So thank you.
Thank you.
And I gather this is to be on the web page for the commission, so that any member of the public at any point in time could look at it and say, here's what the annual plan is, and here they are, and what's getting done or not getting done.
Yeah, that's definitely the goal, and some of these things are viewed much easier on a computer rather than on the large-scale slides here. So yes, they will be public documents available so people can track with us or formulate these things along with us, so people have an idea of where we're moving over the scope, the scope of a year.
Commissioner Chu.
And a quick question. Do you have plans to share this with the Board of Supervisors and their staffs?
I have not specifically reached out to them, but that we certainly can. I think some of them are generally more aware than others of these items, but I have not specifically shared it with them.
Because this relates a little bit, and I don't want to get ahead of ourselves, but when we get into the Supervisor Kim legislation and Supervisor Cohen legislation,
Yeah.
There are a lot of ordinances that seem to come up in the campaign finance reform arena recently in the last few months. So I think it would be really helpful if they knew the work that we are doing in advance, so that they could collaborate and coordinate with us instead of lobbing things in June or July as the train is already gathering momentum and heading down the tracks.
Certainly. If there's no other questions on that section, I'd like to move just to highlight a few of the just sort of things we have upcoming through the policy report, since we didn't have the initiative tracker ready for this meeting, the full initiative tracker, but I'd like to highlight a few items upcoming.
Please.
Turning to, if you're looking at agenda item up 4, pages 2, 3, and 4, so the monthly update of current initiatives, I'm not going to address the CFRO and the Form 700 non-voting ordinance. We'll get into those in the next agenda items. But again, as Commissioner Chu highlighted, we do have 2 separate pieces of legislation that touch on the campaign finance and disclosure arenas. One by Supervisor Kim that was introduced in late July that sort of gets at a number of items. I won't walk you through them. I will tell you that we have been working closely with them to sort of meet with them and discuss how this fits into the CFR draft revision that we have drafted here for today's items, but also how it fits into sort of the Commission's larger policy goals and the intent and purpose of CFRO as an ordinance. So again, if you have any specific questions, please stop me on it, but otherwise I'll keep it pretty high level. For Supervisor Cohen, we had some initial conversations with them about her proposal to provide additional disclosures for members of the retirement boards, the healthcare trust boards, requiring them to submit some disclosures about third-party spending and about contributions that the elected candidates for those boards receive. We are planning on submitting some comment to the the board clerk, the clerk of the Rules Committee. So the public, again, will have access to those items. I believe, and Director Pelham can correct me, but we planned on having a version of that hopefully ready for the next commission reading for you all to take a view at. The other couple of big items here, the slate mailers. Slate mailers are an item that has been on this commission's agenda, in my understanding, going back at least a couple years. But effectively, those things are right now disclosed with the Elections Commission, even though they are fairly political in nature. We have initially met with and gotten some initial data on those slate mailers in a meeting with the Elections Commission, and are working on figuring out some details about administrative feasibility and about how the process of those disclosures that are with elections currently, not in electronic format, just a simple sort of paper filing, how those can be moved over potentially with the commission. And we'll have more details on that as we continue to meet with elections and figure out that process. And then the last two items here, ethics and sunshine training. This is required training for a number of city officials. We are working to take these required trainings and to make them more, or track the process that the Form 700 Statement of Economic Interest do. Right now, we get these things and they're sort of, somebody turns in at one date and they turn in another on another date, and then they have to do a Form 700 on another date. Our goal of that process is to put all of those projects in line with one another, likely via a regulation change, just so people are submitting those within the 30 days of their appointment and then every year thereafter. It just seems to follow in line better and increases the transparency for those city officials that submit these documents and have these required trainings to be doing these on a regular basis. It also simplifies the obligations of both the regulated community, so those turning in these documents, and us, rather not having these multiple dates and different deadlines for these items being in place. It sort of gets us to having one set of deadlines for all of these items. We hope to have something again for that upcoming in the next couple of commission meetings, and we'll keep you informed on that. The last one is sort of our overarching large-scale, multi-year project, which is e-filing for Form 700 filers for all. I won't get into the details of that project, as I think Stephen Massey, our IT manager, is the one that will bring you more up to speed on the larger project. But I will say that we are working on a set of regulations that helps us start that process, helps us get into dealing with sort of fixing perhaps the gaps that are currently exist for the current filers that have to file online. We're hoping to use this project, use this initial round of stuff to bring a set of regulations that closes some of those gaps and loopholes. So with that, unless there's any other questions, I don't have anything further, but those are our projects that are coming around in the next couple of months.
Commissioners, anything further on that? Okay, thank you, Mr. Kunder. We'll take public comment then on this. Okay, hearing no public comment, we'll then move to the next item, which is agenda item number 5, discussion and possible action on staff recommendations to adopt the 2017 San Francisco Anti-Corruption and Accountability Ordinance that builds on the initial Proposition J revision proposal and amends city campaign and government conduct laws. San Francisco Campaign and Government Conduct Code, Articles 1 and 3. And once again, Mr. Kunder, do you want to go ahead and take on that one?
Thank you. So we have dealt with this now at 3 meetings, but for purposes of sort of retreading where we're going through, I'm going to sort of take us on a little longer setback through this sort of piece by piece of this legislation and the process. Please stop me if there's any questions or concerns as I go along, but I will try to sort of highlight these items. For those of you viewing, there is a sort of 8.5 by 14 comparative chart that may help in sort of following along. So I'll begin sort of back to the sort of brief history of this. Chair Keene, I should say, proposed and introduced at the March meeting what was a revision of what is known as Proposition J, which was sort of a revised rehash of an ordinance that was put into place for a brief period around 2001. The revised Prop J sought to limit the ability of individuals using their resources and undue influence to corrupt city officials. It did so by providing that any person who received a public benefit or a person with a financial interest in that benefit would be prohibited from providing contributions, gifts, behested payments, and a number of other sort of political or personal or campaign advantages to the public officials. That was sort of the sort of main section. As we've gone along with that section, we have reviewed the law. This commission saw a number of memos, first in April, then in May, and in June, where you saw an initial draft ordinance which sought to sort of balance the policy goals with recent case law. And that was taking a step back from what we saw in our review of the case law and sort of the policy goals to pull back these class of individuals that were going to be encumbered by the public benefit thing, and while still reinforcing the provisions that we thought were constitutional and that were the areas where we saw the most corruption and the potential for the appearance of corruption. So currently, we have the prohibition on contractors in the city, and this proposed ordinance extends that now to land use matters, persons with a financial interest in a land use matter. So as we go forward with this item, we're still attempting to establish a legislative record for all of these things. But if you turn to, page 37 of agenda item 5, you will see that we've established a number of news items and news stories, other white papers and public interest piece that sort of highlight some of the key areas of corruption related to our version of the ordinance as it's set out here.
I'm sorry, I don't understand. Page 7 of what?
Page 37. Page 37 of agenda item 5. At the bottom, yeah, the page number's at the bottom lower right corner.
All I've got is 27 pages.
For agenda item 5?
Huh? I never got that. Maybe I did. Okay, I understand. I've got it in another place, yeah. Okay.
So going forward, Prop J had some initial other provisions. The personal campaign advantages ban for public beneficiaries was by far the sort of largest piece of that initial legislation. Prop J also had some fundraising restrictions it would have extended to board members, commission members, department heads, and those individuals who had received a public benefit. Again, we reviewed that law in the context of the First Amendment, in the context of other laws, including the City of Los Angeles' provision, as well as the federal Hatch and Pendleton Acts. And in doing so, we determined that we could limit the fundraising abilities of certain board and commission members, but only those officials. Again, I can get into more of the details about why that is the case, but it has effectively been upheld in other jurisdictions, and it is reinforced by the Hatch and the Hatch and Pendleton Acts. The next sort of two large provisions were provisions about debarment, which was just attempting to prohibit public beneficiaries from doing business with government for a specified period of time, and the citizen suit provision, which in the revised Prop J, which would have allowed for citizen plaintiffs to bring and recover 50% of the civil penalties. We have still kept those provisions, however slightly modified. We have kept debarment, but only as the recommending authority for debarment for individuals who violate Chapter 1, that is CFRO. The citizen...
Can I stop and ask a question?
Yeah, please interrupt me.
Commissioner Kopp, sure.
What's the rationale for letting the agency or department do that instead of the commission?
Sorry.
As I understand it, this would authorize not the Ethics Commission, but the department or agency with which the offender did business.
Yes, so
to recommend a period of debarment.
Yes.
And what's the rationale for not having the Ethics Commission do that?
I think we have never been previously a debarment authority, and we don't have the processes and procedures in place to do so. Also, I think in us reviewing a number of other conflict areas and then potentially having to vote on whether to remove someone as well potentially puts us in a duplicitous scenario where we're sort of giving advice and doing all that on the law, but then also the debarring authority. Whereas if we make the recommendations based on our review of those things, it seems that the process is broken out. Otherwise, I feel like we were wearing two hats at the same time.
Well, that's the rationale. I'm not sure I accept that, but it's the rationale. So that leads to the second question. Do you know how many city departments have rules for debarment?
I don't know the number offhand, but it's numerous. I don't know the offhand. I would say that it's at least 10 separate.
Would you find out for me?
Sure.
Thanks. Thank you, Mr. Chairman.
So the last sort of item in reviewing what was the revised Prop J that was introduced in March, and the provision, again, there's some smaller subsets here, but the larger provision is the citizen suit. Again, the revised Prop J would have allowed citizen plaintiffs to bring and recover 50% of any civil penalty. We took that and reviewed that. We reviewed a number of other California laws. We reviewed the PRA, and we determined from a policy standpoint that we would prefer, and we believe it is a better policy to have the commission simply act as a gatekeeper for the citizen plaintiffs. The citizen plaintiffs would provide us, the city attorney or the district attorney, with notice that they were going to file a complaint. The commission or one of the other agencies would then have 60 days to review that complaint and tell the individual or individuals whether they were going to proceed on that item. At that point, if we determined that we would proceed and then the commission, for instance, got an administrative penalty, the citizen plaintiff would be able to receive 25% of that penalty. If, however, we determined that we were not going to go forward with that, the individual could still go to court in that action, but they would then only be able to recover attorney's fees, reasonable costs, and receive an injunction for that item. Again, we can go into sort of more of the details about why that is the case, but effectively is concerns, as you saw through our previous memos, concerns about due process issues, the Eighth Amendment in particular, concerns about us wanting to deal with and be able to review complaints for frivolity, et cetera. So in addition
Mr.
to...
Cunder, just one note
Yeah.
on that at this point, and not because I'll be revisiting it later. The language, the original language that we had for a private right of action,
Yes.
that's a language that exists in Los Angeles and has existed in Los Angeles for quite some time now, right?
That is correct, yes.
And in fact, that's the language that Ms. Pelham, when she was executive director, that's the language in the Los Angeles ordinance allowing this private right of action as we had it originally set out. Now, I know you're recommending that we change it and pretty much a lot of ways do away with it, but I just want to make that point now because I'm going to be revisiting it later on in terms of my final recommendations relating to where this should go. I just wanted to emphasize that now. I'm sorry to interrupt you.
Sure.
Go right ahead.
Okay. So those are sort of the large-scale provisions that we revised from the initial sort of submittal of the revised Prop J to now our meeting today. But during this process, we also took several other items, a couple of disclosure proposals from several Board of Supervisors, Supervisor Peskin, Farrell, and Ronan. We took those reviews and had a memo provided a memo at the May meeting and sort of explained any constitutional issues or any policy concerns that may have been raised by those items. And we combined those items with also a review of staff's review of CFRO that had some additional items. So with that, we provided a couple of other things. One of those is this sort of expanding on what is already in the PRA as a true source or laundered contributions prohibition. This is the idea just that an individual should not be able to use their spouse or children or their employees to launder contributions in the name of another, thus skirting the contribution limits. There is a provision in the PRA that does this. No offense to the PRA, but we thought it was a little light on substance, so we expanded that, taking language from LA and reviews of the FEC's assumed name contribution ban. Then we have a number of disclosures, as I said. Disclosures, and I won't go into detail about it since we've reviewed those now at 4 separate meetings, but disclosures for behested payments, business entities, and bundling. We've gone over this sort of constitutional review of disclosures before, but all of these items, we believe, while they do impose some additional burden on the regulated community, we believe that we've tailored them in a way that minimizes that burden and only gets at those contributors who are likely to have the sort of corrupting influences that we as a commission and CFRO is trying to get disclosed. A new item, again, based on a review of the local California laws, is we are proposing adding a third pre-election report. We know that a number of other jurisdictions have this. We know in our review that there's, depending on which case and election you look at, there's tens of thousands of dollars that are being spent in the sort of final period that wasn't captured by our current reporting regime. So this aims to capture some more of that data in a report that would be due a Friday before an election. So again, there is certainly a burden with that, but we believe that the sort of countervailing disclosure goes, sort of overrides that interest, or that burden, I should say. The last item that I want to bring up, because it's actually a removal of current law, is the removal of section 1.163.5. That is the removal of what is known as the false endorsements provision of the law. This is, I know, a new item. We didn't write a separate memo on this for the removal, but there has been case law that there is no division in the circuits about this item. Unfortunately or unfortunately, false political speech, as it were, has been protected. False speech generally has been protected by both the Supreme Court and at least 3 separate circuit courts. So we believe it behooves us to remove that section of the law, and the current ordinance does that to update and ensure that we are still not enforcing something that is going to bring us into unconstitutional or potentially bring a case against the commission. So I think I will address other items and concerns as we hear them, and I'm happy to go into more detail about the sort of policy and legal items that we go for, but unless the commission has any questions, I do not have anything further.
Any questions by the commissioners? If not, then I'd like to sort of take the prerogative of the chair on a couple of things in regard to trying to structure the discussion, because this is a very wide-ranging, comprehensive set of recommendations and procedures, something we haven't dealt with in terms of its scope before. And again, just sort of summing up the history of what this was. There was a Prop J that was passed in the early part of this century, which did a number of things that are in this measure to try and cut down on corruption in city government in terms of being able to get favors and pay various indirectly to obtain particular political benefits without any kind of disclosure to the public. And what has been recognized, I think, generally by the city and over the course of the last couple of decades has resulted in considerable soft corruption in San Francisco city government and in regard to things that are done for contracts, land use, favors, other types of things. And so Prop J, it did regulate much of this stuff, but over the course of about 3 or 4 years, a number of measures were introduced that just did away with Prop J sub rosa. In other words, none of us really knew what was happening. The citizens didn't know what was happening. They were just sort of cherry-picked out in various other measures, and by 2007, Prop J was gone. And then the civil grand jury and other friends of ethics pointed out that this was something that had happened, and the measures against all of this aspect of soft corruption no longer existed for the protection of San Francisco. Then 2.5 years ago, when Supervisor Rennie was chair, he, Commissioner Rennie, I keep, there's another half of Commissioner Rennie, which was a supervisor for a long time, whom I dealt with for many years, and so I reflexively do that often. I'm sure Commissioner Kopp probably does the same thing. But Commissioner Rennie, when this was raised by Friends of Ethics and the civil grand jury, appointed me as a committee of one to look at it and to establish whether or not we could reinstate Prop J. So it was a long period of time before I really got back to it, but it was about a year ago. And working with Friends of Ethics, working with the civil grand jury, working with staff, we put together a resurrected Prop J, which was put before the commission back in March. And the staff has done a marvelous job tuning it, putting it together for delivery for us to vote on tonight and to recommend it to the Board of Supervisors. In addition, in the input of this measure, we've had the benefit of Supervisor Peskin, Supervisor Farrell, and Supervisor Ronan adding their language in regard to many things, and we've embraced that and thank them for it. So that's what we have before us. So what I'd like to do to sort of get the discussion going is, again, taking the prerogative of the chair, and I was the one who, and Commissioner Kopp and I have worked on this quite a bit now since he's been on the commission, have been working with Friends of Ethics, Civil Grand Jury, and the staff. There are three three specifics that I would want to address in regard to this measure and change. Three specific, very specific things. Otherwise, the measure, I think, is terrific. So procedurally, if there's no objection, what I'd like to do is state what those three things are to the commissioners. And if the commissioners then want to vote as to whether or not they want to accept these three things or take them one at a time, that's fine. We can do that. But let me state what they are. One is in regard, just get some water here. One is in regard to something that I already sort of pointed out with Mr. Kundert, and that is that in the original Prop J, you had this private right of action on the part of citizens to institute a private right of action where there has been any kind of corrupt activity or prohibited activity in regard to the matters relating to Prop J. The staff, I had discussions with the staff on this, and they had certain feelings about it that private right of action, and Mr. Kundert is, pardon me, given the reasons, I won't repeat them, that private right of action should be pretty much done away with or really watered down. But in my opinion, that private right of action is very essential. It's part of it. And it's also something, again, that's all we did is we took the language that is the language in the that Los Angeles has had, and has had it for a number of years, and has had no problems with it in terms of frivolous types of activity by citizens bringing private rights of action. And the Los Angeles law, which is that which was the original law that we have in the original statement of it, gives that private right of action, and I would recommend to my colleagues that we keep that private right of action. Do not change it to what the staff, with all due respect to the staff, is suggesting. It's not necessary. I don't think there's any due process concerns, and it's something that we want to encourage individual citizens, if they see these things, to point them out and to go forward with them so that they can be addressed. The second thing, pardon me, is that the staff has done a great job in terms of trying to specify who and what activities that this should apply to. And essentially what it has done, it has picked out land use and contracts, which probably covers about 95% of where the problems come up, land use. But it doesn't cover all of them, because you have all sorts of hanky-panky relating to things that would not come under that by big movers and shakers in regard to things like Uber, other types of things where I could go through a laundry list. Mr. Marsteller, his chart was a pretty good example of the soft corruption and the people involved in it and the things that have been that are addressed. So what I would suggest is, rather than just limiting it to land use, boy, I'm sorry about this, is that say it's specify specifically that it applies to land use and contracts with the city, as the staff has said it should be. It should apply to, but then use the additional prohibition, which is in the March language, that in addition to land use and contracts, it also applies to persons who seek a public benefit. And then it gives kind of a laundry list of those persons who seek a public benefit. I'm not going to go all through them. And what type of businesses those public benefits would be. It has land use sort of as a subset. We take that out because we've specified land use particularly. Now, there may be some problems in regard to specific situations there. If there are, there are. But I think what that does, since it's broad enough with these categories, it captures these people and agents and elements of soft corruption in the city that are not captured just by land use and contracts. Uber, for example. So that's the second thing that I would ask that we embrace as part of this. And the third thing is a very specific thing that was the Friends of Ethics and the civil grand jury people have said should be specifically part of this. And that is another aspect from Los Angeles law on commissioner fundraising. There are parts of Section 3.231, which are in the new measure that the staff has put together, relating to commissioners' activities. But there's nothing specific relating to commissioner fundraising. And Los Angeles has a specific law, which I would say we should add to 3.231, which says a member of a city board or commissioner who is required to file a statement of economic interest, or general manager or chief administrative officer of a city department shall not do either of the following: solicit, direct, or receive a contribution from a person who has, or in the preceding 12 months had, a matter involving city action pending before the board or commission member or general manager or chief administrative officer. 2, engage in prohibited fundraising, and that's what we've got listed, defined in the Act itself, on behalf of an elected city officer, a candidate for elected city office, a city-controlled committee. This prohibition does not apply to members of city boards or commissioners or general managers or chief administrative officers who are engaging in fundraising on behalf of their own candidacies for public office. So Los Angeles has had that for a while. And the reason that this specific aspect of it, over the course of the last few years, we saw an FBI investigation, we saw wiretaps of people where you had commissioners commissioners who were involved in all sorts of prohibited activities and soliciting, which this would specifically address. So now I've thrown a lot on your plates, commissioners, and I apologize for it. But with that, what I would like to do to sort of move the discussion along, if we can, is ask for a motion that we adopt the staff's statement of the measure, the staff's statement of the San Francisco Anti-Corruption and Accountability Ordinance with those suggested changes. Do I hear such a motion?
Also move.
Is there a second?
I'll second.
It's been moved and seconded. We also have to have a vote on Commissioner Lee's recusing herself from this matter. Is there a motion that Commissioner Lee may recuse herself?
May I ask through the chair, do you want to be recused on this? All right, also move.
Is there a second?
Second.
Okay, so let's.
Can I ask a question of Commissioner Lee? This is a matter of sort of public policy. And I assume, although you were just appointed today, you feel that you can't vote on whether or not the policy set forth in this proposed ordinance is good or bad?
Thank you, Commissioner Rennie. I come to this commission with a lot of personal beliefs, and personally, I really felt that these are the things that's really going to help the transparency and accountability of the intent of the commission and the proposition. However, I do feel that whenever I take an action as a commissioner, I want to make sure that I have all the information to be informed so that I can vote not on my personal belief, but based on all the facts, based on all the information that is afforded to this commission. So because the only information that I have had on this particular issue has been just the readouts, and I had not been able to participate in the previous rich discussions that the commissioners have, that's why I wish to be recused. That does not mean that I do not believe in the spirit of this action item.
And I'll support the motion.
Okay. The motion to recuse has been made and seconded. We'll call the roll on that. Vice Chair Chu?
Wait a minute, somebody wants to.
On the recusal of, may I ask the city attorney, do we need to take public comment on the vote for the recusal of Commissioner Lee?
Yeah, if I could make a suggestion, it seems that there's two pending motions before the commission at this point. Perhaps you could take public comment on both at the same time.
I think that would be
Well,
that would be a little bit hard. You want to talk about the recusal of Commissioner Lee. Do we have to have public comment on that?
I think it would be better if you took public comment, but just to be clear, the commission can take public comment on the entire agenda item at one time.
Well, no, we're not. Okay, what I'm gonna rule is that that in regard to Commissioner Chu's motion to recuse herself.
Commissioner Lee.
I'm
No, it's
sorry.
my motion.
Right. Okay. Yeah, the motion to recuse her. That we'll take public comment on that by anyone who wants to comment on it, and then we'll continue with our discussion relating to the main matter.
After voting on the motion to recuse.
Yes, yeah, and then we'll go forward with that. Yes, sir, go ahead.
My name is Bruce Wolf. I'm speaking on behalf of myself. I'm concerned about the, Commissioner Lee recusing herself at all at this point. Commissioner Lee is a new member. She hasn't had an opportunity to hear or concern herself about this particular item. This is a very important and very large, widespread changing item for thousands of nonprofits in the city. And I think the public should have the benefit of her vote and have the benefit of her insight. And I would encourage you to, if you're going to recuse her, that you postpone this entire proceeding on this item until she has an opportunity to read it, to ask questions about it, and actually get to know the staff because she's so brand new, to understand what it's all about so that she can make an informed decision. I don't think the public should be deprived of her knowledge or her input or her vote, whether she's supportive or opposed to it. I think it's important. There are only 5 of you. You each represent a very specific sector of government. It's not, you're not all appointed, as equal members of the public. So I would urge you to take some pause and think about this. And I would urge you to, if you're going to recuse her, to then postpone the movement of the item itself until she has that opportunity. Thank you.
Mr. Chairman,
Commissioner Kopp.
may I make an observation? I heard Mr. Wolf's statement, and I want to correct one part of it. Each ethics commissioner does not represent one part of the public. Each member of the commission and the commission as a whole represents the people of the city and county of San Francisco. Thank you.
Any further public comment on the matter? Okay, so we will now vote in regard to whether or not Commissioner Lee may be recused. Vice Chair Chu.
Aye.
Commissioner Rennie.
Aye.
Commissioner Kopp.
Aye.
And I also vote that she may be recused. So Commissioner Lee is recused from voting on the matter.
Well, I think the motion was participating.
To
in other words.
participate in the matter
Yeah.
at her suggestion, which, again, I might add, it's exactly the same thing I did on at my first meeting here. She's was appointed 3 or 4 hours ago. We have an enormous amount of stuff here. And so what I did on my first, even though I had been appointed a week before, I wasn't familiar with a lot of the stuff. Unfortunately and strangely, this commission doesn't allow someone to abstain. If she just wanted to, if we had the ability to abstain, she just could have abstained. I tried to abstain and was told no, I couldn't do that. But if I felt that it was not ethical or proper for me to go forward and vote on it because I didn't have enough information, I could recuse myself. So she's doing, in my opinion, exactly what she should do. Okay, so now what we have, commissioners, we have the motion before us in regard to all of the things relating to the 2017 San Francisco Anti-Corruption and Accountability Ordinance. Discussion by the commission.
Mr. Chairman, I made the motion, but does it include other matters, some of which I have questions about? Let me give you an example so that it's perhaps easier to respond. I think that one does certainly be included. There's a comment on page 5 of the staff report, and this is item 5 that is in the first full paragraph on that page, stating that limits on expenditures raise constitutional doubts. Furthermore, limits on gifts and conflicts of interest already exist in the campaign and governmental conduct code and are not appropriate additions to campaign finance, reform ordinance. And I guess the question I have, anybody in the public, including Mr. Bush later, can answer, why isn't present law sufficient? The question I have for staff in the next paragraph is about having a financial interest. I want to be sure that includes stockholders and bondholders. Through the chair.
Staff want to, Mr. Kunder, do you want to address that?
Yeah.
So when you talk, I have to clarify, for financial interest, you mean the definition in 1.104? Because that's just a land use item.
All right, so I got to be sure that
Yeah, so
the
let's
amendment,
yeah.
which is inspired by the chairman, includes corporate stockholders and bondholders.
I would, it's anyone with an ownership interest of at least 10% in the project or property. That's insufficient for you?
I don't know.
I think it would be.
Huh?
I think it would be, yeah.
Okay. Then the next paragraph on that page, the last, that's the long paragraph, deals with nonprofit organizations, and there's a sentence that says the narrow construction of this exception is designed to exempt charitable organizations that provide community services using city funding apply for a land use decision that relates to the provision of those city-funded services. For example, an organization that operates a homeless shelter using city funds wouldn't be subject to the prohibition on contribution and behested payments if that homeless shelter became the subject of a land use decision. And my note is, why not?
Well, assuming that they are a charitable organization and the project is dealing with, is partially, it meets the test. So it partially or wholly is funded by the city. They are a charitable organization, and that charitable organization and the project are that project is dealing with the provision of whatever you want to call it, low income and other low income services. So you're asking why the exemption generally? So as far as why we included the exemption in this section, it has to do with the number of items. I think first and sort of foremost is that we assume that if you were receiving the substantial amount or wholly funded by the city already, you were sort of already being endorsed by the city, and you were also receiving a substantial amount of your city funds from the city. Therefore, the likelihood that you would have to seek additional funds through an elective official or other, that likelihood that you would attempt to corrupt the official for further dollars was reduced in that sense. We also have a countervailing interest that the provision of low-income services is a traditional public service being performed by these institutions where normally the government would provide those services, but in the sort of long history of nonprofits in the city and county of San Francisco, that those services, many of those services are now being performed by nonprofits. So sort of two interests. One, that we thought there was a diminished capacity for corruption, and two, that there's a strong countervailing interest that these services, these traditional public services, were so important in the area of sort of traditional public services that it sort of overrode any remaining corruption interest.
I won't argue it in great detail, except I note that the city and its taxpayers don't control the budgets of nonprofit entities to whom taxpayer funds are being transmitted. Under the subsection C, there was a system or a note here about not dealing with transfers between candidates or committees. In other words, what you referred to as intra-candidate fund transfers. And you note that the initial Proposition J proposal had suggested a ban on intra-candidate fund transfers. And then you state the ordinance doesn't include that ban. Why not?
If you recall from our initial memos on this, there's
that
SEIU,
goes back to June, and I don't have it.
There's a specific case on point that found in California that found it unconstitutional. SEIU v. something that found that exact scenario unconstitutional. A Ninth Circuit case.
All right, so that's the answer to that. Huh? And then how about this requiring contribution limit attestations? These contributor cards. Is that included?
Yeah, it is.
Is that a unreasonable burden on contributors?
It's an additional disclosure, but how that is reported could be as simple as a check mark and a signature or an equivalent electronic signature stating that you are not a prohibited source. You're already prohibited if you gave that. Now we're just requiring that you attest to that fact. It's an additional informational piece for the candidate committees and other committees that protects them from having to sort of do the back end work and provides them a safe harbor. It also provides an informational aspect in that it reinforms the individuals, the contributors who may not be aware of this law, that they are prohibited from giving if they are one of these sources. So I would say it provides at least two interests.
All right, so you think the overall benefit of it outweighs the practical expenditure of time and attention?
Yeah, correct.
That's the judgment, huh?
Other areas, other...
I'll be interested to hear from any, if there are any in the room, campaign managers or campaign treasurers about that, because I could visualize it having a depressive effect upon private donations to campaigns. But, okay, I'll accept that analysis, and I think that completes the questions I had.
Commissioners, any further comments?
Yeah.
Or Commissioner Chu, did you? I feel you had. I thought you said.
Yeah, no, it'll come to me in a minute, so.
Yeah, I think Ms. Pelham wants to weigh in here.
Thank you, Chair Keene. I just wanted to clarify what I think we heard, because I think there may be a section that either we're misinterpreting or that we may have misheard. You mentioned, I think, in your comments, the first suggestion about the private right of action, that the proposal would either reduce or eliminate that. And I wanted just to point to page, it's section 1.168 on page 28, I guess, of item 5. And there is language under existing section 1.168B, if I'm reading this correctly, that says the city attorney or any voter may bring civil action to enjoin violations or compel compliance with the provisions of Chapter 1. But there is language that's being added, suggested to be added on the next page from on line 5, that talks about the recovery of penalties assessed if there is a judgment that's been rendered, which I believe was a different level than the initial Prop J proposal had. I wanted to just clarify if that's
and it's
a provision.
also different from the LA law.
LA law is 50%, I believe.
Right, yeah. And
So that's what you were looking to try and get
right,
comparability on?
I think the LA law is a very salutary example for us to follow.
Okay. And then we had a clarification on the fundraising piece as well. Do you have that on your?
Well, before you leave that, do we have a definition of voter? San Francisco voter, California voter, New York State voter? And the second part of the question is the observation. Why do we need to use the word voter? As I remember, there aren't many, but a handful of state statutes which allow a private citizen to sue, or a private member of the public to sue. It isn't circumscribed by registering to vote or actually voting, or even, I don't know, I can't remember, even citizenship. I think any resident can, who's paying taxes. It's a taxpayer suit, essentially. That's why it's like a key TAM action, where you expect, if you win, you're going to get some money from it, from the recovery.
It's really anybody's suit, anybody who can point out that there is some sort of corrupt act going on and wants to institute one of these actions, whoever it is, even if it's an individual who's here undocumented. I don't think a voter adds anything to it. So I think Commissioner Kopp has a good point there in regard to the word voter being, is it necessary?
This is current law, so this is a good discussion about whether the commission wants to amend this. There is a definition in existing law that says voter shall mean an individual registered to vote in San Francisco. So that's the definition that would apply here, unless the term voter were changed, for example, to person or individual.
Or you could say resident.
Or resident. Or resident.
Commissioner Rennie, would you propose that as an amendment?
I would be perfectly happy with it.
Okay, is there a
I'll
second to?
second that.
All right, so we have a proposal and second. We'll vote on all of this collectively to change that to resident.
And by that, to clarify, you mean county resident, city and county of San Francisco?
No.
Yes.
Okay, then you just want person, I think.
That was, no, so just person.
You can say any resident of the city and county of San
Yeah.
Francisco.
Okay.
Any resident.
Thank you, that helps clarify.
Okay. Yes, Commissioner Chu.
Deputy Attorney, City Attorney Shen, I have a question. Could you share with the commission your view on the constitutionality of the outright ban on behested payments and the likelihood that it would pass muster?
This may be not necessarily the best forum to enter into a discussion of that, but certainly there is some case law supporting the idea that fundraising, asking for donations and such, constitutes expressive conduct in the First Amendment. And because of that, it's likely to draw heightened scrutiny, and the Commission should take that in mind and keep that concern in mind as it progresses with staff's proposal.
Commissioners, any further observations or comments? Or Mr. Kundert, did you have, does staff want to weigh in further on anything? Jessica?
I'm sorry. So, and just one clarification from our standpoint as well. So, on the fundraising prohibition or restriction for city boards and commissioners, I think the difference there between LA is that LA extends that actually beyond boards and commission members to department heads and to actually anyone and to other sort of private citizens that are doing business with the city. We have reached out to other subject matter legal experts, and they have replied that they believe that further prohibition of LA is troublesome, if I can use their paraphrasing words. So that is why we have limited it to boards and restricted fundraising from boards and commission members. Further, the department heads are not included, one, because some of them are not directly appointed by those elected officials, but two, that would require substantial further meet and confer responsibilities to forward on this law.
I think the meet and confer, though, that would be done by the Board of Supervisors who get this recommendation as to whether or not they're then going to enact it into law. So that might be the case, that meet and confers. I don't think we need to worry about.
Well, Mr. Chairman, I would like that activity covered, which was just outlined by staff. I mean, the boards and commissions, one of the worst offenders in the state is a member of the Board of Equalization.
Yeah, and they would be covered.
Whose wife's charity has gotten close to $1 million over his 7 or 8 years of public service.
We've got that covered.
All right,
So this
okay.
language, Commissioner.
And to clarify, one other change that would be you're interested in from the Los Angeles model is that this would extend not just to the individuals appointing authority, but to any elected official. Did I hear you correctly on that?
That's pretty much what LA has done for quite a while, and I think we ought to do the same thing.
I have two things.
Jessica, go ahead.
Yeah. If I could, real quickly, I just wanted to address the meet and confer obligation and make sure the commission is aware that could take a substantial amount of time. The whistleblower ordinance has been going through the meet and confer process for about a year, so it might be a good idea to divorce that from this and do it separately so that you have some provisions that can go into effect before the 2018 election, and then the parts that would require meet and confer would be separate.
This is that's the letter from the unions?
And the discussions with the union.
Is that the meet and confer you're
Yes.
mentioning?
Yeah.
I think it's a good idea to separate that provision.
Yeah, all right, if we can separate the one out that needs meet and confer.
But department heads aren't currently included, so it would not have to be at this time. It's not in the current provision.
Okay,
If we included them, then we would have
Well,
to.
where is it?
It's not included.
Huh?
It's not currently included, so if we did include it, then it would trigger a meet and confer.
well, let's not have it then. There's no reason, I don't think we want to hold this up.
We can put that item on another track to bring
Yeah,
forward with
we-
additional
Yes.
looking
We
at
can do
public.
that, yeah, we can do that down the line, but let's not sidetrack this into the whole thing into a meet and confer aspect. Thank you very much, Ms. Bloom.
I had one other question about your change to the civil penalties section.
Yeah.
So are you suggesting that we revert back to the language from Proposition J revision, or are you suggesting that we just increase the penalty availability in this current version to 50% from 25%?
Revert back to Prop J.
Okay. If I could have a moment to explain why we changed it the way we did for all the commissioners' benefit?
Okay, sure.
Okay. So the original Proposition J amended the citizen suit provision that already existed, the private right of action that already existed in the Campaign Finance Reform Ordinance, to give individuals who bring a lawsuit an opportunity to recover 50% of the civil penalties that a superior court judge might award to the voter, as it were, soon to be resident. We changed that to, instead of incentivizing people to go to superior court in order to recover their civil penalties, we changed it to incentivize people to come to the Ethics Commission with their complaints in order to recover civil penalties. And we reduced the award to 25% from 50%, just to discourage the frivolity of lawsuits, to decrease the amount of the possible award. So I just wanted to highlight that that was the reason why we made that change, and it's a policy call about where you want to incentivize the filing of cases and complaints. So that's your call to make. But I just wanted to make sure you understood that that was the reason why the change was made, and it was not intended to gut or minimize or take away the Proposition J proposal.
In regard to the LA action, that's done in court, is it?
Right.
Okay.
And the citizen doesn't need the approval of the city attorney or any other official, correct?
No, that's not correct. In Los Angeles and under the Political Reform Act, and under all citizen suits, actually, you have to first notify the authority with enforcement capabilities and give them 60 days. And after the expiration of the 60 days.
That's understood. But after that 60 days, can the citizen proceed?
Yes, and that remains true under this.
So all that is a notice provision.
Right.
All right.
There
Well,
remains a notice provision under
yeah.
the amendment.
Okay, fine.
All right.
Very good.
But just so I'm not sure I understand, if we adopt what Commissioner Keene suggests, the only thing that would be different would be that it includes a private right of action in addition to filing a complaint with the commission or the district attorney, but if they file their own lawsuit after the time period when no action is taken, they would be entitled to the 25% range that the present draft has, without any change that Commissioner Keene is asking for?
I'm not sure. I can explain again, but so if you look at page 28 of Agenda Item 5, Section B1 remains the same. We did not change anything in Section B1. That gives voters a private right of action, access to Superior Court, to file a citizen suit after the notice has been given and obtain an injunction. So under current law right now, anybody in this room, if they felt like the Ethics Commission was falling down on its job, or the city attorney's office or the district attorney's office, they could file notice with us, wait 60 days, and then go to court and ask for an injunction to stop the bad activity. They could also recover attorney's fees, and they could also recover costs. That's existing law. What Proposition J's revision did was also give individuals who won in Superior Court a 50% of a civil penalty award that a Superior Court judge might award or decide would apply. So basically, it gave the Superior Court judge authority to assess civil penalties against a respondent, which would include anybody in a campaign, for civil penalties of $5,000 per violation, and then split that in half and give half to the citizen and half to the government. Our change says that if you notify us and any of these entities, the city attorney, district attorney, or ethics commission, take the complaint that you're giving to us and institute its own enforcement action, then we get civil penalties, and we would give 25% of those civil penalties to the citizen, and 75% would go to the government. So that's the difference.
I guess all I'm wondering is, what is it that Commissioner Keene says you didn't do that Friends of Ethics or somebody else wanted in this particular draft?
The change we made was we eliminated the ability of the judge in Superior Court to assess civil penalties against a respondent in a private right of action by a citizen versus respondent where the government's not involved. So we took that out, and we instead made it that we changed it so that the award of civil penalties must involve some action by an enforcement authority. And the enforcement authority being the city attorney, district attorney, and ethics commission.
Which essentially then puts it at the control of the city attorney or the other enforcement authority in terms of determining whether or not they'd go forward, or if they say, well, we think this is a frivolous suit, not go forward.
Yeah, right. They would not.
In that situation, even the citizen can't really pursue it and get any kind of anything for himself or herself for having pursued the action, even if it's found later on to not be frivolous.
Mm-hmm.
So
yeah, except for costs and attorney's fees.
Yeah, that's the thing. I think we want to keep that incentive in there in terms of people seeing that there is corruption like this, that there is some incentive for you to push it, not just as a citizen, but look, you're doing something for the common good, and there is a reward for you if in regards to doing that as part of a damages type situation. I think that's what LA has, and I think that's something that really gives teeth to the whole aspect of a private right of action. And there's been no problem with it in LA.
Yeah, so that's a policy decision. Yeah. So we understand that under the Prop J proposal, people will tell us that they're going to file a lawsuit, then they would go to Superior Court, and if they win, they will get 50% of civil penalties.
Which is what I think we should have, and the way it's been. Okay. Any further discussion by the commission? Commissioner Rennie.
I just had a couple of questions on the section dealing with the statute of limitations.
Yes.
One may be only grammatical.
Oh, okay.
But subparagraph C2 says, no civil action alleging a violation of any provision of this chapter shall be filed no more than 4 years after the date. I just wanted the double no there. No civil action shall be filed more than 4 years after the date.
That no should come out.
That's right.
Yeah. And then, as I understand the language,
Could you tell us which section? Oh, sorry.
What page?
this is
Bottom right corner.
Yeah,
the section under statute of limitations
I
on
saw
page
that, too.
18. Pardon me?
Do you have a section number? We're struggling, I'm sorry, at the table with our pagination to try and identify where you are.
Well, it's section 1.135, supplemental pre-election statements, then section 1.168, enforcement, advice. Then go to section called statute of limitations. I have an old copy or something?
So in the current version that was presented tonight, the staff has not proposed any changes to the statute of limitations in 168.
Pardon me?
In the version of the legislation the staff has presented tonight, there are no proposed amendments to 168 regarding statute of limitations.
Well, there are any amendments to it, but this question is, there is language that I just read to you.
Take out the second no.
Uh-huh.
Take out the second and no.
That's right. Oh, is that?
That doesn't make any
I
sense.
saw it too.
Mr. Rennie's correct.
All right, that,
But the other part of it that I was questioning about is, it says, or the date that the facts constituting the cause of action was discovered by, and city attorney, and then by the Ethics Commission.
It appears you got a wrong version of the.
All right, is that all out?
Yes,
There's
correct.
no- what does the language say now about statute of limitations?
It's the same that it was previously, so it's just the 4 years language that you noted. The no statement may still be an issue, but it's just the 4.
But does the present version that you've got in front of us now eliminate the language about discovery?
It doesn't even touch it. That's not in it.
But why did it go out? Why did it go out? Whether this is whether I've got one that is a draft that was earlier, why did you eliminate the provision about when the statute of limitations starts to run?
Yeah, I guess we didn't change it when there was some contemplation from staff that it might have been an issue previously, but it wasn't in the scope of our review.
What is the draft that's before us tonight? Because I did insert a copy I was dealing with and didn't print out yours. But what does it provide as to the statute of limitations and when the statute starts to run?
Yeah, I have to. The provision currently reads. Where are you looking? Any other civil action alleging a violation of any provision of this chapter shall be filed no more than 4 years after the date on which the violation occurred.
Oh, but what does it say about when the statute starts to run insofar as the enforcement agency is?
It says nothing to that effect.
And why doesn't it?
We simply did not address it. What you have there was us reviewing and revising it to see if the language could be made better or alterations based on staff's review of the ordinance as a whole, but it was ultimately determined that we could come to no conclusion on language that was better than what was currently that's currently on the books in CFRO. We thought the language as written was sufficient.
But that's the reason I raised the question, is that that's been a problem with the statute of limitations when the commission doesn't know about it, but the violation occurred more than 4 years ago. When does it start to run?
From this context, it is the date it occurred.
But wouldn't we prefer to have it only starts to run when the commission becomes aware of it?
There was thoughts about that, but if you do that, then there is effectively no statute of limitations. if we would have had to had language that we would have had reason to know at the very least, because if it's that, then there is no effective statute of limitations.
Chair Rennie, or Commissioner Rennie, I think this is part of an internal discussion we had. It was reflected in an earlier draft. If the commission has, as a policy matter, would like to see the language clarified here or strengthened to try to address that issue, we can come back with some language that attempts to do that. And we can refine the language that we worked at that we decided was not sufficient. But certainly if that's something at the commission's policy direction, we can take a look at crafting some language to get at that issue for greater clarity.
Because I don't think there's any legal restriction on our putting the statute of limitation only to start to run when we become aware of it. But that's a policy question if you want to do that.
I think that's a good point. I mean, we had that problem big time a couple of years ago in regard to one of our major matters in terms of it's starting to run when from the time of the occurrence, or if if there are no facts upon which the commission should be aware of it at the time the commission becomes aware of it. How's that?
And then, if I may supplement that, if it is awareness of the commission, the awareness should be based upon a written filing of such an alleged violation with the commission.
That's okay. Commissioner Rennie?
I don't know if
Yeah, why don't we just add that then?
Chair Rennie?
Yes, Commissioner Chu.
So just for my benefit, Ms. Bloom, could you recap for us where we stand again on the private right of action? Because we had revisions to Prop J, and then we have the current version and Chair Keene's suggestion. So I would just like to have everyone on the same page as to what is before us now.
So the existing law status quo gives any voter a private right of action for an injunction. Prop J gave a private right of action for an injunction plus the recovery of 50% of civil penalties. That essentially gives Superior Court judges authority to assess civil penalties against respondents. Our proposal requires that the city attorney, district attorney, or ethics commission prosecute the case in order for a civil penalty award to attach. So there wouldn't be an opportunity for a citizen to recover penalties from a respondent on their own. The government would have to recover the civil penalty and then give the private party a chunk, a piece of that award. Those are the three options: original status quo, injunction only; Prop J, injunction plus civil penalty in a private right of action. Our proposal is injunction plus civil penalties where the government is the prosecutor.
And Chair Keene's
But what we
proposal-
have before us now in regard
Right,
to
so-
my motion, which was,
Your motion was Prop J.
it's Prop J.
Yeah,
It is
sorry.
Prop J.
Okay, so clarifying question. If the commission has initiated an action against someone, does the private citizen also still have the right to bring a private action?
Yes.
And it's not a voter, it's a resident
Sorry,
of San
resident.
Francisco.
Yeah, that's right. Resident. Okay.
Yeah, no, Andrew's pointing out that the voter cannot bring a private right of action if the Ethics Commission responds to their notice. Or is made a finding of probable cause, right. But so the voter would have to find some other avenue that we did not, some piece that we did not,
The resident.
the resident, under current law. So we're, under current law.
No, let's, since we have before us the Prop J, right of private action, and we've broadened it to say resident, I think that's what we should address, because we have before us language that we adopt that rather than what the staff has recommended. If commissioners feel that they don't want to adopt that, then we'll do that in the vote. But but that, we don't go back to that at this point yet. We may go back to that if we reject it.
Okay, so just a clarifying question for
Sure.
you, Chair Keen. Then, with regard to the private right of action, if from your view, the proposal that you would have us consider now, if the Ethics Commission is pursuing a case against an elected official, for example, then there would still exist a private right of action by a resident against that same individual. Is that correct? So
That's correct, yeah. And that's the LA law, and that would be the Prop J law, yeah. You have this additional impetus that we want to give to the community at large to address corruption and to bring it forth. Okay. Any further comments by the commissioners? No. If not, we'll take public comment.
Except I do say,
What are you taking public comment on, the whole item 5?
Yeah, on the whole item 5 with the 3.
Fine.
We could do that, or if we could take a break now before we go into public comment. I know.
I'm not.
Okay.
see, Commissioner Lee, what you're missing? Aren't you sorry?
All this fun, yeah.
Wish I were here 2 years ago.
I just want to comment on the 3 amendments, and I'd like to be able to come back.
Mr. Bush.
I'm Larry Bush. I'm from Friends of Ethics. The LA private right of action does say that if the Ethics Commission were to initiate an action, then that's the end of it. The citizen cannot go further than that. So the LA says that the Ethics Commission can act. It also lets it then go to court to have the court decide on a penalty, whereas the draft from the staff does not allow that to happen. And in fact, there's a 2-track system in this, as I understand the staff draft. One is if the Ethics Commission says we're not going to act, but there may be something there, go ahead, you might get 25% of any penalty. But if the Ethics Commission says we don't think there's anything there, you can file, but you're not going to get any penalties awarded at all. So that's a lot less. And also in LA, it's a 40-day turnaround. And in LA, the language is a person residing in the city. It does not use the word voter or anything else. It's a person residing in the city. In terms of the commissioner fundraising, the LA law allows commissioners to write a check themselves to make a contribution, which was an issue that the nonprofits had raised a couple of times, that we shouldn't take away the right of commissioners to make a contribution. But it does say that they cannot bundle or raise money for officials. And in LA, it applies to raising money for any elected official or candidate for those offices, which makes a lot of sense in San Francisco, where we have split commissions. So, for example, the police commission, some are some by the supervisors, some by the mayor. So who's the appointing authority? The way that the staff has written it, it's the appointing authority, but who is that? Especially when you consider the fact that the board can reject a mayor's appointment, as they tried to do with some of the port commissioners, where they voted against them, even though they passed. But a minority did vote against them. So how do you deal with any of that? I think that the best way is to use the LA thing, which bans fundraising but not a contribution and applies to any official. In terms of contributions that are coming from groups that do land use, the staff language is pretty limiting. It enunciates a number of city agencies, but leaves a number of them out. For example, it does not include the airport, where we know there was a huge fight about an assignment for building a garage. It does not include the fire department, even though we had a citywide ballot measure over whether we were going to put fire stations or whether we were going to close any of them. Doesn't include the school district, where we have excess land. That's how we got the San Francisco Center built. They sold that land for a developer.
I'll move additional time to Mr. Bush.
If we do
Well,
that,
I could-
if we do that, then we have to give it to everyone else, Commissioner Kopp. So I'd recommend, if we don't want to be here all night, let's.
Some may not be as valuable.
I understand that, but I think, Mr. Bush, your time is up.
Thank you. Those are my points on those 3 sections. I have other sections that I would like to talk about.
Yeah.
Good evening, Commissioners. Debbie Lerman from the San Francisco Human Services Network. I want to start by saying we support good government laws and we support disclosure of behested payments. But we have a number of nonprofits here tonight who want to speak about the harm that the proposed behested payments ban will do on nonprofit fundraising and the ability to recruit and retain high-quality members of our boards of directors. There are a number of provisions I'd like to comment on, but given the limited time, I'm going to focus on 1.126. We live in a city that is so compassionate that it is known for its San Francisco values, that is known nationwide. And what that means is that the community-based organizations of this city are on the front lines serving vulnerable populations in partnership with the City and County of San Francisco and the philanthropic community. We are national leaders, and now we are facing a hostile federal government, and we are all waiting for the shoe to drop on the budget cuts that are going to come from the feds. And I honestly cannot believe that I am here looking at a San Francisco City Department that is having a serious discussion about banning charitable solicitation and contributions. This is a direct attack on our San Francisco nonprofit health and human service sector. This is the reality of contracting here. If you're a for-profit, you don't receive behests. You're not going to be hurt by this. What you get with the city is a contract that is fully paid 100% plus profits. If you are a nonprofit, you get a contract that pays part of the cost of your contract, and for that privilege, you are then expected to go out and raise the rest of the money. And city officials commonly and very appropriately help you do that. They support the organizations in our city and in our district, and they support the organizations that serve their constituents. And I do want to clarify that the city approves those budgets. You cannot spend taxpayer dollars without the city department approving your budget. This proposal would hamstring the ability to raise money. It would ban common fundraising methods. The city would be basically cutting off an arm from our nonprofit sector. You can't raise money this way anymore. It hurts the city. It'll hurt the poor. It is unprecedented. No other jurisdiction bans behested contributions. This goes too far. There is not a corruption boogeyman around every single corner. What is the problem? This is not narrowly drawn to get at the problems. The vast majority of these contributions are worthy. They also, by banning volunteer boards of directors, we are preventing volunteers from making personal donations. And I believe that would be found unconstitutional in court. They have no financial interest whatsoever in the contract or the organization, and we should not be forcing our dedicated volunteers to make choices between serving on a nonprofit board of directors and giving up their First Amendment rights to support candidates or make contributions when public officials make a call to meet pressing public needs. Thank you.
I think Commissioner Chu.
Yes, thank you for your testimony. I had a question when you said that part of your organization's budgets will come from the city, but then you have to fundraise in order to make up the shortfall.
That's
Do you
correct.
have a ballpark amount as to how much you receive from the city, or if there's a range?
I'm
and
sure
what
some of the
portion-
nonprofits who are here tonight could give you a ballpark on how much of their full budgets comes from the city.
Yeah, okay, thank you.
Can I ask you?
I'm sorry. Commissioner Wren.
Would you, just for give me a specific example of what you're talking about when you say, if this ordinance is passed about behest contributions, that your organization
member
would be
organizations.
harmed by?
Well, for example, having a public official speak at your annual fundraiser and ask the folks in the room, who are going to be your board members and probably folks from other city contractors as well, to donate to the organization. That would be prevented. If the mayor puts out a call publicly to donate to a particular type of organization or to a particular cause, whether it's a Maya Angelou statue or the opera or the Red Cross in the case of an emergency, folks who are with city contractors or their boards of directors would not be able to write a check in response to that request for a donation.
Kyle, is she correct?
I think that's a fairly broad reading of it, of what the behest was. The scenario we're contemplating is these organizations that have city contracts, so there's an interest in that their contracts be given to them in a merit-based way, that these individuals can then, if they need money, nothing prohibits them from soliciting money. Nothing prohibits the directors from soliciting money. Nothing prohibits them from going to an elective official and asking them to provide them with more money. What we're prohibiting is a scenario where the director or the executive staff goes to an elective official or speaks to them at a fundraising event and says, our organization needs money. What do I need to do? Where do I need to give of your organizations for us to get that money? That's a narrow situation that seems to be.
That's what
The behest of payment is limited to legislative, governmental, and charitable purposes at the behest of a city elective officer or candidate for that city elective office. The person also has to be in the sort of path of the contract.
Because I understand, and maybe I'm naive, but as I understood, what you're focusing on is to prohibit the mayor, for example, going and saying to donor X, give money to this organization because I support it. And that person who's going to make it is going to get some favor from the mayor for their contribution.
Correct.
But not, that's why, the illustration that.
But that is what the language says. It just says complete ban, an
No,
elected
it
official
does
cannot
not.
solicit, and a contractor cannot donate.
You've overstated it tremendously, and all of the nonprofits who made that argument have overstated it. This addresses corruption, and it addresses the kind of quid pro quos that mayors, other people get from people whom the person wants them to do a favor for them, so the mayor said, well, okay, but you got to give to the whether or not there can be a travel fund for people in government to go to China or other.
I appreciate that that's your intent.
Those are the things that this addresses. The horrible ifs that you talk about, with all due respect, Ms. Lerner, they don't exist. They're not what we're doing here.
That's not what it says, and I appreciate that that is your intent, and suggest that the language needs to be reworked to clarify that there must be a quid pro quo as opposed to just saying complete ban on contributions.
Yeah,
because as written, a contractor can't drop $1 in the donation.
I understand where you're coming from, but the term nonprofit can cover a multitude of sins, and people on nonprofit, we're talking about little children or people who have difficulty. When we talk about nonprofit, we talk about the Koch brothers nonprofit type situations. They have all of these huge organizations for taking care of political. Karl Rove's organization is a nonprofit. These are the things that we're looking at, and the idea that somehow it's addressing these little charities and that's nonsense.
Mr. Chairman, may I ask a question?
Yes.
You made the statement that the city approves your budget,
Your
meaning a
contract budget.
nonprofit.
Your
The city
contract-
approves, wait a moment.
Yes, sir. Yes, sir.
The city approves this tender housing clinic's annual budget?
Not your entire budget, but any portion that is funded by the city.
Well, that's right. You want to see where the tax money's going, but
Exactly.
it doesn't approve the entire budget. And apropos of the chairman's comments, it's one of the oldest games in the city. And I've seen it for over 50 years of nonprofits being able to bet on the winner in a race for elective office. Okay. Thank you, Mr. Chairman.
Thank you, Ms. Lerner. Next public comment.
My name is Kathy Lowry. I retired from Larkin Street Youth Services in June of 2016 after 9 years of working as their Chief Development Officer. It was definitely the best job of my long career in both for-profit and nonprofit work. And as Chief Development Officer, I appreciate the importance of the reforms being put forth in the legislation being proposed today. Seems that there's a question of how it's being interpreted, and I hope that that can be cleared up by before the vote is taken. I am opposed, as it's written currently, to Section 1.126, which, as Debbie said, proposes a ban on behested payments by city contractors. If it's enacted the way it's written, this would put a significant restraint on the ability of Larkin Street and other nonprofit contractors who are here tonight to maximize our capacity to raise private funds. For example, like many nonprofit contractors in the city, we ask our elected officials to come and speak at our events, and we're very honored and proud when they do. As they are presenting, it's only natural for the public official to call for support for Larkin Street to this room of donors. And in this room are people like our board members, as well as a number of other guests who might have contracts with the city that we don't even know about. Under the onus of Section 1.126, these potentially generous donors would, the way it's written now, or could be interpreted now, would be prohibited from responding to the elected officials' call for support. It could result in a bottom line for the event, in response to your question, Commissioner Chu, that could be hundreds of thousands of dollars less in funds raised than had originally been hoped for. In fact, it's particularly unfair and unnecessary to restrict contributions from the volunteers that serve on Larkin Street's Board of Directors. They do not profit personally if Larkin Street has city contracts. Board members are often our best and most generous donors, and some of them support other causes as well. The law would make it more difficult to attract these generous board members. And while I'm in favor of the current requirement to disclose behested contributions that are $5,000 and up, I have a real concern for the infrastructure that would need to be put in place to support the follow-up, to track all the donations from all the nonprofit contracts where an elected official was present and spoke. This wouldn't be a wise use of time and funds for the city or for the nonprofits. Thank you.
Thank you.
Hi, my name is Kim Bender, and I am the Development Director for GLIDE, the GLIDE Foundation in the city. And I do hope that the language does get cleared up, because that's why I'm here too. Obviously, the community of San Francisco relies heavily on GLIDE to serve some of our most marginalized folks. As one of the longest standing and well-respected social service organizations in the city, we are called upon to respond when the community is most vulnerable. We need advocates within the city government to continue to support GLIDE's mission by being champions of our work. We serve approximately 750,000 meals a year to San Francisco residents. We provide daily shelter reservations, emergency assistance, violence prevention, HIV and Hep C services, free childcare, and continuing to lead conversations around social justice. The mayor, supervisors, and other city representatives help make collaboration between GLIDE and local businesses, individuals, and contractors possible. This legislation, the way we understand it, and perhaps it can be revised to address the quid pro quo situations that we do certainly oppose, would prevent those important public-private sector collaborations from benefiting the public good. For example, when GLIDE was working to build housing for the homeless of San Francisco, We relied on city officials, private developers, Glide board, and staff to all work together to make that project happen. We developed 3 buildings that currently house over 600 people. Those people would still be homeless if those collaborations had not been possible with all of those players. Glide recognizes and fully supports the importance of good government rules and hopes that it is not the intent of this commission to ban these types of fundraising activities. So I hope that you will find a way to make that very clear in the language when you pass this very important provision.
I have a question.
Commissioner Kopp.
Does Glide Foundation still endorse candidates for the Board of Supervisors, mayor, and other
No,
elected city
absolutely.
officials?
No, we do not endorse candidates. We endorse measures, but we've made very clear in our social justice work that it is against the nonprofit rules. Thanks.
Mm-hmm.
Thank you.
Thank you.
Good evening, Commissioners and staff. Thanks very much for taking the time to listen to our comments. My name is Torrin Lewis. I'm here on behalf of the Alliance for Justice. We are a national association of over 120 civil rights, environmental, and other social justice organizations. And a big part of what we do is to assist nonprofits in their advocacy efforts. And a lot of that work deals with public charities and other 501c3 organizations to help them stay within their lane, so to speak, as charities when they engage in advocacy. And so from that perspective, I just wanted to echo a couple of comments and add some of our own thoughts regarding the advocacy capacity of nonprofits and how it could be affected. One concern we have is that the ban on behested payments from those organizations with city contracts could cause nonprofits to inadvertently violate the ordinance because of only the actions of their unpaid board members in their free time. In other words, board members engaging in political activity through donations, contributions, could cause nonprofits who aren't even aware of those contributions to be in violation of the ordinance as it's currently written. Another point we wanted to make on that subject is that unlike similar provisions of state law, these unpaid nonprofit directors are being prohibited from engaging in political activity, even though there's no risk of a private financial benefit inuring to them in their role as nonprofit directors. So these are people who are not involved in the contract negotiations, and they do not stand to profit financially through their connection to these organizations. Finally, a point that I don't think has been made yet today is the repeated recusals section 3.209, which would allow the commission to recommend removal of certain commission and board members for repeated recusals under existing law, we believe is unduly harsh in that it effectively penalizes paid nonprofit staff who not only go above and beyond to serve their communities on these boards and commissions, but then take steps to comply with existing law and recuse themselves in the manner appropriate. Those citizens are now penalized for being involved in their communities and, in fact, following the law. And we believe existing law, Government Code Section 1090, the Political Reform Act, Section 84308 dealing with pay-to-play, and similar local provisions are already strict enough in requiring recusal to avoid an actual financial conflict of interest in those cases. For those reasons, I respectfully ask that those provisions be reviewed.
Thank you.
Good evening. Lauren Kahn from Health Right 360. We are a nonprofit organization providing substance use disorder treatment, primary care, and mental health services to 35,000 Californians, including 10,000 San Franciscans who are homeless and very, very low income. I'd like to address the issue of behested payments or requests from city officials for nonprofit organizations, as we clearly view that the current document in question really prevents that. And I want to talk to you a little bit about the way that we use city funds. We do, in fact, contract with the city to provide healthcare services, and the funds are not enough to serve the people who come through our doors every day. They're not enough money to actually, for example, help a person who's coming out of substance use disorder treatment following a long prison term find housing and link them to housing services, or provide case management for people who have diabetes or heart disease to be able to find healthy food to safely manage their illnesses. Also, my organization just recently purchased and renovated a 50,000 square foot building that we had to purchase because we were constantly losing our properties where we were providing services in order to not face skyrocketing rent, for example. And we are funding that completely through donations. And one of the vehicles that allows us to actually do that is having support from elected officials who say, this is an organization that is not only good, in my opinion, but that is good for the city and is good for the people in the city of San Francisco. And without support from our trusted officials, it makes it significantly more difficult. When you ask a celebrity, it may be a little bit more exciting, but just because you're a famous musician doesn't mean that you know anything about the city. And it's our elected officials who actually do. Also, just want to remind that as a nonprofit, we cannot and do not support elected officials when they are running for office. So there's no conflict there. Thank you.
Thank you.
Hi, good evening, and thank you to the Ethics Commission for taking the time to put together a thoughtful response to the corruption that we know exists, the coercive relationships that result in unfair business practices and unfair distribution of resources that continually fail to protect the residents we care deeply about in San Francisco. My name is Lynn Dolce. I'm very new to the nonprofit landscape. I'm the CEO of Edgewood Center for Children, Youth, and Families. And prior to my current role, I was the Director of Foster Care Mental Health within DPH, overseeing all of the behavioral health services for children in child welfare system and their families. Prior to that, I developed and led programs within the Department of Psychiatry at General Hospital, employed by UCSF for 16 years. So I am no stranger to the politics or the myriad of financial and ethical concerns that large institutions are faced with on a daily basis. I find the proposed language very confusing and extremely broad. I'm concerned about mostly how it will be interpreted, and also that without proper interpretation, that in my role as CEO, I will need to be consulting with attorneys all the time about how each activity surrounding fundraising is handled. This is going to cost my organization time and money that we definitely do not have. I worry, for instance, that even having an elected official speak at our annual gala, where we do most of our heavy fundraising, will be considered suspect under this language and legislation. I am also concerned that attracting volunteer board members, as has been mentioned before, where there is absolutely no quid pro quo by nature of the fact that they are volunteering their time to do something good for a cause that they believe in, that they would have to choose between participating on my board and, say, for instance, as Debbie mentioned, responding to a natural disaster like an earthquake if the mayor asks for all of us to contribute to the Red Cross. I'm worried that the restrictions in Section 1.126 will cause civic-minded people to greatly reduce their donations or even stop donating altogether. Edgewood is the oldest child-serving nonprofit in Northern California. We served 9,000 families last year. We provide behavioral health services to children and youth that no other nonprofit in the region does. We have a crisis residential treatment service for children who are experiencing a psychiatric emergency in order to avoid an inpatient hospitalization. We have residential treatment for children in child welfare where they have no home and no one else to provide services. We run a non-public school in San Francisco, which provides continuity. I think that I'm just going to end by saying our contracts are historically underfunded, and we have a provision in every contract that says we have to match the number of funds that we are provided to do business in San Francisco. I'm really urging you to review the language in 1.126 and prior to voting. Thank you.
Thank you.
Good evening. My name is Courtney Mulhern Pearson. I'm the Senior Director of Policy and Strategy at the San Francisco AIDS Foundation. We're a 501c3 organization that have been serving people living with and at risk for HIV for more than 35 years here in San Francisco. Similarly to other organizations, we also are not allowed to endorse candidates, so that is not a conflict that 501c3 organizations face in California. We support reducing undue influence in government decision-making and would support most of the reforms in this legislation. But like the speakers before me, we do have concerns about Section 1.126 and the way that it's drafted currently. And our interpretation of that drafting would limit a lot of the fundraising that we currently do that allows us to serve more than 16,000 San Franciscans living with and at risk for HIV. For example, we just completed a multi-year capital campaign to open a gay men's health center in the Castro, San Francisco's first gay men's health center. Because we were at capacity at our previous sites and were not able to meet community demand, we now are able to contract with the city to perform more than 16,000 HIV and STI tests a year, and we're looking at operations to how we can improve those and increase those numbers. But throughout the process, we had tremendous support from our supervisor and the whole Board of Supervisors, the mayor, the mayor's office, the public health director, and the public health department because they recognize the value of the program that we're looking to open and how cost effective it would be for the city to contract with us to provide services that they could not afford to provide on their own. And we believe that from our reading of the language as drafted, many of the fundraising activities would not meet the letter of the language that's been submitted that we reviewed. And that would include things like speaking at fundraising dinners, speaking at campaign fundraising events, and various fundraising activities that go along with running a multi-year capital campaign such as that. Now that we have moved into our newly expanded space, we're able to leverage our city contracts and private fundraising dollars to increase the number of clients we're able to serve and the breadth of services we're able to provide. It's cost effective for the city to provide us contracts to do that. And to answer one of the earlier questions, I don't have the exact number, but I believe our government contracts make up just under 40% of our overall budget. And that's city and county, but also state and federal contracts. And the rest of that is private fundraising that we do on our own. So thank you very much.
Thank you.
Commissioners and staff, my name is Don Falk. I'm the CEO of Tenderloin Neighborhood Development Corporation, TNDC, and I do want to take a moment and distinguish. Sometimes people get us confused with Tenderloin Housing Clinic, which is a different organization. I won't repeat much of what you've heard tonight. I share the concern about ambiguities in the behest language and just really encourage you to help clarify any confusion. And I do want to maybe take a moment to share our situation in order to provide a little bit of context. So we own and operate 3,500 homes for very low-income households. 90% of them earn under $1,000 a month, so it's a very vulnerable, very low-income population. In addition, we operate an after-school program. We provide food security programs, and we have health programs. Our after-school program gets a contract from the Department of Children, Youth, and their Families for about $175,000. The program itself costs $700,000. And so every year we are raising the difference. Another contract that we have with the city helps support the housing that we provide for formerly homeless households. It's about 25% of the people living in our units. And that contract, at the end of every year, the city will audit to be sure that we don't receive any more money than is required under the contract. At TNDC, our overall fundraising obligation is about $3 million a year, which is very challenging and very difficult goal for us to meet. We do 2 big events every year, and for us it's pretty standard to ask our local elected official to come and vouch for the quality of our work. And it would really be a shame if we could either not do that, or if they're doing that, put the people in the audience at risk. Thank you.
Thank you.
Good evening, Commissioners. Ken Reggio. I'm Executive Director of Episcopal Community Services. ECS is a large social service and housing organization providing food and shelter today and tonight to 673 homeless men and women at 4 locations, including our 2 navigation centers. We also provide supportive housing for 1,200 formerly homeless men, women, and children at 11 locations. We offer a variety of other support services for homeless and formerly homeless people in our city. About 80% of our budget, ECS's budget, $33 million budget, comes through service contracts with city agencies. About 6% comes from private contributions, and the rest from federal sources and from tenant rents. Without the 2% that we raise from foundations, corporations, and individual donors, ECS would close its doors. Contracts and tenant rents fall significantly short of the cost of operations. And because we depend so heavily on the generosity of our donors, we're sensitive to any effort to curtail contributions. We also know that that's not your intention in expanding good government legislation. But we think particularly on the issue of banning behested payments by board members of city contractors, that will be the effect. And I would say the problem isn't one of overly broad interpretation, as was suggested, but it's one of language not being specific enough to make clear that that's not your intention and that's not how it will be applied. ECS, like other organizations, enjoys strong relationships with our city partners. We appreciate when the mayor or members of the Board of Supervisors lend their names to an honorary committee for one of our fundraising events. We appreciate even more when the mayor or supervisor puts in a good word at the event, speaking of our work of sheltering or housing or providing food to people experiencing homelessness, and encouraging our assembled donors, including members of boards of directors of organizations that contract with the city, to dig deep in support of the work. It's hard for me to make a connection between the mayor's or a supervisor's request in this instance and some favor that he or she might get in an election campaign. And I can tell you that even Section 1.126 as it stands, which bans our board members from contributing to candidates' campaigns for public office if they have or will have authority over contracts that support our work, is discouraging and has a potentially negative effect on efforts to attract civically engaged members of the public. I support disclosure of behested contributions. State law already calls for that, but no jurisdiction bans behested contributions, and I urge that San Francisco not become the first to do that for the effect that they may have on organizations like ours. Thanks.
Thank you.
Hi, Commissioners. Again, it's Charlie Marsteller for the record for Friends of Ethics. If you could activate your machine here, I thought for the public, I would put on the screen a list of behested payments. Let's see, there's a blow-up here. Freeze, auto. Do you know which one raises it? Zoom. Maybe it's just the turn of the knob. There you go. I did want to say this is a list of behested payments. And one could say this is a list of pay to play in San Francisco, because this is not the list that 40 or 50 years ago our mothers and fathers saw coming in the door in San Francisco to nonprofits, even adjusted for inflation. some of these numbers break $100,000. These are things, for instance, Mr. Gascon got a desk in glass and chrome. He's probably not the only one, and I believe that was from Mr. Conway. And it was thousands of dollars. So I have a list. I'm going to give it out again because we have a new commissioner, although she's not in the room. Did she leave the room?
She had to leave because of a family matter.
Oh, I was thinking she's should see this list.
She will.
I'll make
We'll
sure
get it to her.
that you get copies. They're online, I believe, at this point. And it's clear that something is going on in this environment. And I think the commissioners are aware of it, given your history in the city and your track records here. And this is why you are responding. What is not as adaptive, unfortunately, is the understanding of the 501s who are caught in the middle. And they surely have to understand that the commission has a job to do, and that is to resolve this problem. And by saying it's going to bankrupt your organization, let's get more constructive in our comments, because I think we need to know what adjustments can be made to the law to make this work, because somewhere there's got to be a compromise. But it sure is not letting this go on without abatement. Thank you.
Thank you.
Thank you very much, Commissioners. I'm Jan Masaoka. I have two hats that I'm wearing here tonight, and I have 3 points to make. So the first point I want to make is as the CEO of the California Association of Nonprofits, which is a statewide alliance of more than 10,000 nonprofits. And our concern over this particular idea is that it places the onus for avoiding behested payments, not on the public officials that ask for them, but on donors who may very well unwittingly be making such donations. Seems to me that we should place the onus on the people who are asking for them, not the people who may have heard them or may not have heard them at a fundraising event and are therefore barred. So that's our number one concern. Second thing I wanted to respond to is the question about what percentage of contracts. Our statewide research has shown that roughly 20 to 35% of government contracts with nonprofits are unreimbursed. So that means it's 20 to 35% that nonprofits have to raise from private sources, for example, to be able to complete the work on those contracts. And the third thing I want to speak as is a former board member of the Asian Pacific Islander Wellness Center here in San Francisco, an organization to which I have made donations of well over $5,000 at various times. Recently, I went to a fundraising event of a museum, and I won't tell you what museum it was, and I won't tell you what elected official was there, saying, this is a great organization, we should all support it. Now, as a board member of API Wellness Center, I can't write a check to that museum. This just not to mention writing a check to API Wellness Center. And what if I had been in the bathroom when he was saying that? Who would know that I hadn't actually heard it? So as a donor, I'm concerned about the unenforceability of this particular law. I'm hoping that sort of these questions can be sorted out and cleared up, and as the previous speaker said, that, as Kyle said, that would be a broad read. Well, then it's not what it's intended. I don't think that's what the Commission is intending, so let's just take a little bit of extra time and make sure that the law says what we do intend it to say.
Thank you.
Hello, Commissioners. I'm Tony Kelly from the Potrero Hill Democratic Club, speaking here on my own behalf. And I deeply appreciate your work on this. It's desperately needed to clean up corruption in the city. I don't believe, after hearing your conversation before public comment and hearing public comment, I don't believe you're ready to move forward on this. And if you do happen to vote it out, please give the Board of Supervisors a lot of leeway to clean up the very messy pile of details that still need to be worked out in this legislation. I just want to underline a few points here, some of which have been brought up before, some of which have not. First, especially Commissioner Keene and to Friends of Ethics, I deeply appreciate the expansion of this beyond land use and contractors. That's necessary. There was a lot of corruption and listed corruption that Mr. Marsteller put up there that is skipped under that particular definition. So I appreciate that larger broadening the scope of the types of actors you want to catch. I wish that was matched with attention to detail in the rest of the legislation. And let me draw your attention to the definitions. So it's page 2 and page 3 of the legislation. The definition of behested payment. Behested payment shall mean a payment for a legislative, governmental, or charitable purpose made at the behest of a city elective officer or candidate for city elective office. So when Commissioner Keene talks about the Koch brothers, well, they fund mostly 527s and 501c4s. That's different than 501c3s, which are also tax exempt, but tax deductible, too. There's a difference between charitable and legislative and governmental. In one of the letters you have from Friends of Ethics, it's mentioned the relationship between city officials and making behest contributions cannot be overstated. Indeed, millions of dollars are contributed to entities under the direct control of city officials. Commissioners, solve that. Entities under the direct control of city officials. The charitable nonprofits aren't. As 501c3s, they can't endorse and support candidates. They have different missions, and none of their profits can, they don't make profits, and they can't inure to the benefit of any individual. That's IRS code. The definition on page 3 of make at the behest of. Made at the behest of shall mean made under the control or at the direction of, in cooperation, consultation, coordination, or concert with, at the request or suggestion of, or with the express prior consent of a candidate for office or city elective officer. This is where the confusion comes from, commissioners, about someone speaking at a public event. So if you say this measure doesn't include that, then why is it written that way? This is the type of work you need to do. I would also draw a distinction between members of for-profit boards, often who are stakeholders, shareholders of companies, and do get paid for their service, and members of boards of directors of nonprofits, who by definition are volunteers. The legislation does not do that. That's an important distinction and goes right to the heart of what you're talking about here. Thank you for listening.
Thank you.
Thank you. I'm Nancy Nielsen. I'm Deputy Director of Lutheran Social Services. We currently serve over 2,500 people every day, most of whom were formerly homeless. And like most of my colleagues in this room, our job is to keep them from becoming homeless again. We work very hard at that. To answer a couple of questions that have come up and in support of what's already been said, most of our contracts don't cover more than 80% of our actual cost. It is an expectation if you contract with the City and County of San Francisco, you will raise that other 20% somehow. We do that. We all do that. And the other thing that's important to know about the nonprofits in this city is we do work together. We are the safety net for the most vulnerable people, and we do this through partnership and supporting one another's work. If you're concerned about our budgets, we are monitored. We are audited. We have receipts for every penny we spend, and we have to show them every year. This is not free money. We work very hard to turn around and support the people who are dying on our streets every day. So please take a good look at what you've written and understand there are often unintended consequences of language. And the language that we read may not well be the language you intended. We ask you to take a hard look at that and be careful. Thank you.
Thank you.
My name is Calvin Mulch. I'm the chair of a nonprofit board, San Francisco Information Clearinghouse. I've worked as a staff member in a nonprofit my entire working life. I've also been very politically active in San Francisco, generally always as an individual. And I will not go into detail, the fine detail and distinction that both your staff has made in trying to deal with 501c3s as related to 501c4s. But I want to talk about what is the narrative of the commissioners about 50 years of experience, Commissioner Kopp, that you talk about on the old game in San Francisco. Sir, I believe I've been with you in many of those 50 years and not a few campaigns that we've been on the same side of. And let me remind you of a couple of facts. I endorsed you for mayor. You did not win. I did not pick.
You have to remind me?
Right. Well, that goes counter to your narrative of the oldest game in town of nonprofits picking winners. No, nonprofits generally pick losers because we're engaged in trying to benefit the least of San Franciscans, and we choose not to do too well with incumbents. And we spend an awful lot of time trying to being beaten back by the winners of the folks that we did not endorse as individuals. That is the history of nonprofits, community-based and faith-based nonprofits in San Francisco. We endorse generally the losers, not the winners. And we endorse the losers because generally they're on the same side of the issues. And what the nonprofits are about in this town, health and human services, with contracts for the city to serve the city's poorest and most vulnerable populations. This is not the Koch brothers, and please don't insult us by us not knowing the difference between a 501c4, which is the Kochs, and 501c3s. Nobody endorses candidates. Nobody plays that game. We endorse poor people. We try as best we can to serve them. And oftentimes, that's overcoming our political endorsements, not cashing in on our political endorsements. Thank you.
Thank you.
Good evening, Chair Keene and commissioners and staff. I'm Hulda Garofolo, former civil grand juror and a friend of ethics member. I just wanted to say I've listened to the different speakers about nonprofits and all the good that they do. And for some, that's true. But I also want to remind this panel that there are 501c3s, nonprofits, that accept money from the city and donations, but don't follow their mission statement. In fact, they have actually been guilty of several missteps and gross negligence. So it's important that nonprofits, no matter how good they say they are, and that they are helping human services, there are some things that need to be held accountable, because they are also where the dark money can be funneled. Thank you.
Thank you.
Good evening, Commissioners. Fernando Martí with the Council of Community Housing Organizations, representing 25 affordable housing developers and community activists. I want to add my voice to many that you have heard before, including the voice that we just heard. We need to keep our nonprofits accountable, and I think this is the part where, as you heard from Tony Kelly, the details really matter in this legislation. Tony read for you through the definitions of what behesting means. I just want to repeat, and I think you've all got it in front of you, the section that says prohibition on behested payments and contributions. No person, and I think it's important, the definition of person, including board members, volunteer board members of nonprofits. So no person such as that may make a behested payment at the behest of an individual holding a city elective office. And you've heard the kinds of examples that this might be. If that is not your intent, if your intent is not that at a museum function, a elected official says, this is a great museum, you should support it, and then you want to prohibit anyone from actually supporting that museum, then let's be clear and let's change that language so that those kinds of situations are not what is represented here. I've served on various boards at various times, and I think, again, one of the questions here is about making a behested payment at the behest of a candidate for office held by such individuals. Again, how you define these things are really important, and I hope that you'll take the time to review both those definitions of behesting and this particular section and go through some of those examples. So, this is not what we're talking about. Supporting museums, supporting the opera. If Mayor Lee wants us to support the opera, we should probably do that. If we want to support a housing agency, we should be able to do that. Thank you very much.
Thank you.
Good evening once again, Commissioners. Tonight I'm speaking on behalf of the Haight-Ashbury Neighborhood Council. I also serve on several other nonprofits that have not taken a position on this yet, so I will not be speaking on their behalf, but the sentiments are the same. Just a couple of procedural parts first. Just note that under the Brown Act 954.3, every action item must allow the public an opportunity to speak. Every action item. It specifies it in the language. Second, just want to get some clarification just for your benefit on the introduction of the three items that Mr. Keene, Chair, had introduced. Are any of those items currently in writing that are before you today? And if they're not, then you can't take action on them. The Brown Act is very clear on that. You can't take action items that do not appear on the agenda. So if they're not part and parcel or in writing in anywhere that's been presented to the public today, then I would postpone those. Also, in constitutional construction, in writing, it's supposed to be written in a way that's relatively understandable. You have a lot of highly educated people in the room here that are also lawyers, that read these things for how they're presented. And if you're going to tell us that we're reading it wrong, then it can't be it's not written in a way that we understand it to be. And that's the way law has to be written. It has to be written to a level of understandability for a fairly low level, a high school level, so a person can reasonably understand it. So if what we're reading is ambiguous to mean something else, then it's not being spelled out detailed enough. Now, I know you have resistance in categorizing specific types of organizations, but we do that in so many laws in the city already. I don't see why there's a resistance to focus on the types of organizations that you're naming, because every single one that you name and everybody else names is none of these people that are standing here. None of them. And so we feel that this is a dragnet. It's, San Francisco is the highest concentration of nonprofits anywhere in the country. So this affects everybody, and the confusion of the language, when this gets promoted either to the supervisors or to the ballot, you're gonna scare the hell out of all these nonprofits, because you're gonna put a lot of focus on the nonprofits, and so are the Friends of Ethics and many other proponents. So I would be very cautious about that. I'm a staunch supporter of open government, and I don't like the pay-to-play politics and all of this. I respect and I support a lot of what's in here, but I think that there's too broad a brushstroke, way too broad, and you really have to narrow it down. So I really would urge you to hedge on this tonight. Don't vote on it. Take more time. Actually, get us to come meet with you, because we were never invited to the table when this was introduced to you at the jump. We had to spend literally days off of work. I had to take days off from work and drive from San Rafael all the way down to the city to be able to discuss this with other people when we had such a short period of time. Meanwhile, staff has a lot of time to work on it because that's their job. It's what they get to do. And the people that introduced it, they had years to work on it. And then it just gets introduced or sponsored instantaneously. And then we only get a certain amount of time when it's posted publicly. So it really feels a little unfair, a little unbalanced. And we'd just like a better and more balanced opportunity to be able to do that. Thank you, and for allowing me the extra time to
Mr.
speak.
Chairman, I have a question for staff.
Yes.
Commissioner.
No, Mr. Wolf, not for
Okay,
you.
thank you.
Weren't these interested persons meetings the subject of public notice? How many?
We held 3 from the original one when it was introduced in.
All right, so and they were
6
publicly noticed, and 3 were held.
6 were held, 3 separate, 3 notices, 2 meetings each.
2 meetings each. Thank you. Okay.
Good evening, Commissioners. My name is Peter Cohen, and I'm with the Council of Community Housing Organizations. You heard from my colleague Fernando earlier, so I'm not going to repeat a lot of what you've heard from nonprofit representatives who took the time to come out this evening. Just a couple things quickly. I want to make sure to acknowledge that the staff did a lot of work, and there were interested person meetings. There were a couple of rounds of ordinances. We went through those and made several comments. And a number of issues were actually tightened up and refined, and we appreciate that work. So this has been a winnowing process, but we are unfortunately left with a couple of very serious concerns about the implications for the ordinance. So this is not to say there was not a good effort on a lot of issues, and maybe this is just a policy difference. You've heard from many nonprofits today. I just want to acknowledge there was a couple who couldn't make it. Sherry Williams from Treasure Island Homeless Development Initiative, who sent an email earlier today to staff. Richard Heasley from Conard House. These are both organizations working with formerly homeless residents. You heard from the Alliance for Justice and the California Association of Nonprofits. So in other words, the implications of what you're doing here are not just for us in our little San Francisco sandbox, but for the nonprofit sector writ large. This is a precedent-setting ordinance. And we're proud of our San Francisco model. As Bruce Wolf said and Debbie Lerman started off, we have a lot of nonprofits doing community-based work in San Francisco. That's very intentional. It's not accidental, and we're fortunate, and we should be proud of that. It also means we put a lot of organizations doing good work at risk when we try to do certain things to tighten up what we might see as holes for dark money or other kinds of things, and putting them at risk of getting caught up in the dragnet that Bruce Wolf described. And therefore, the details absolutely do matter. The undermining of common fundraising practices, the stuff that these folks do every single year in and out to raise, I guess we heard an average of 25 to 30% of their budget needs, to potentially tighten that up or make it go away or put it at risk is unconscionable, as well as having volunteer members of their boards have to choose between engagement in civic activities, legal contributions versus having the professional expertise with those organizations. We have to figure out how to resolve this. We submitted a comment letter on Wednesday. It has 3 specific sections with recommendations on how to, if you will, fix them. We've appealed to staff. Maybe we're at a stalemate, but we're asking you folks to at least allow the time to get it done right. To have an ordinance leave this chamber today after having heard the testimony from all the professionals in this room who are not here to argue for illegal contributions or dark money, but are here to ask you to make sure that they are not the unintended consequence, the collateral damage of a good effort. How to resolve that is important, and it needs to be resolved before this simply gets pushed forward. We're asking for your accommodation, and we want to work with you. Thank you.
Thank you.
Hi, this is Karen Lau from San Francisco chapter of Represent Us. I want to thank the Commission. I want to thank Supervisors Peskin, Farrell, and Ronan. I want to thank the staff who we've been working with. Appreciate the fact that we've had 6 to 7 plus months to review this. We've had 6 separate meetings to provide commentary. And I want to remind everybody that the citizens and the residents of San Francisco have waited for 16 years for this law and this responsibility to run government correctly and avoid corruption. We've heard a lot tonight about a specific group that's going to get hurt, but I want to remind you that this legislation helps to protect everybody. Corruption is endemic and it hurts everybody. It redirects resources, it takes faith away from government, it corrupts all over. There are people who will not run for government because they see, oh, This elected official is channeling millions of dollars in behest payments. That being an elected official is not about doing good. It is not about the mission-based stuff. It's about your ability to funnel cash from one side of the room to the other side of the room. And that's what we're seeing. This list of things that Charlie put up, all this money that's flowing around, it looks tainted. It causes people to lose faith in government. Now, I respect the work. I've worked in nonprofits for 25 years. I've donated to nonprofits. I do every year. And so, yeah, work there. I think, we do have to rely on lawyers. We do have to rely on experts in the commission to go and look at the sides of issues. And I believe you'll catch those things. I don't believe that the dragnet's so wide that you're going to all of a sudden accidentally, not be able to distinguish between a $25,000 payment from some large profit organization that's routing it on behalf of a politician to a nonprofit organization in order to get a favor from a politician. That's not going to be confused with standing up at a fundraiser with 100 people in the room. The stuff we're talking about is the go into a room, close the door, and ask for a bunch of cash to be directed to somebody in order to gain political favor. That's the act of corruption that we're talking about, and the residents of San Francisco want to work on it. So yes, I think there's a process. We've gone for 6 months. We're going to go on to hopefully to the Board of Supervisors. I imagine the Board of Supervisors will have some things to do. Let's all work together. We've had a great track record working with Peter and Debbie over the last couple of years to try to get things clarified. But let's keep things moving forward and do whatever you have to do tonight to clarify and make sure the residents of San Francisco get a corruption-free government. Thank you.
Thank you.
Good evening, Commissioners. Anita Mail, Pillsbury, Winthrop, Shop, Pittman. First, it is unfair to the public to adopt this motion without giving the public the opportunity to review the specific language of the three provisions suggested this evening. Section 1.114A requires all committees obtained from donors who contribute $100 or more certification that the contribution does not constitute a prohibited contribution. Commission staff plans to provide a contributor card for this person. How will this provision apply when committees receive online contributions via the internet from donors? It is my understanding that internet vendors may not permit the collection of such extraneous information via their websites. Section 1.124 will mandate that all committees obtain and disclose unnecessary information about business entity donors who contributed $10,000 or more in a single election cycle, including the principal officers and city contractor grant information over the last 24 months. This imposes an incredible reporting burden on all committees to collect and disclose this information and on business entity donors to provide the information. The public has the right to know which entities make contributions, the amounts, and the recipients of those contributions, but that right should not extend to unrelated information about the donors. Section 1.124 appears to be in an attempt to discourage business entities from participating in city elections. Section 1.125 requires an elected officers controlled committee that receives bundled contributions from a single person totaling $5,000 or more to file a report disclosing lobbying matters a bundler attempted to influence the officer over the past 12 months. This provision may result in unlawful activity. California Penal Code Section 424, California Government Code Section 8314, and San Francisco Campaign and Government Conduct Code Section 3.230C prohibit the use of public resources for political or campaign activity, including the use of staff time, or engaging in political activity during working hours or on city premises. Section 1.126 will prohibit certain city contractors from making behested payments. Since behested payments include payments to charities made at the behest of an elected city officer, this provision would prohibit those contractors from making and elected city officers from soliciting charitable payments needed for a variety of purposes, including payments to the Red Cross for emergencies created by earthquakes, floods, and other natural disasters, or for sporting events such as the International Olympics. Since such charitable payments are made for the public good, this section should exempt behested payments made to charities. Similarly, Section 1.127, which prohibits persons with land use matters from making behested payments, should exempt behested payments made to charities. Section 1.127 unfairly targets persons with financial interest in land use matters. Because a person with financial interest is broadly defined to include not only the entity, but its officers and all members of the board of directors, this provision would impose a tremendous burden on the entity, its officers, and board members. Developers subject to the reporting requirements of the Developer Disclosures Law should be exempt from having to file additional reports under this section. And finally, sections 3.203 and 3.207 create new conflict of interest provisions which are not needed. The state's conflict of interest laws and its detailed regs mandate recusal when financial interests conflict with an official's private interests. Numerous FPPC advice letters have been issued over the years, providing much needed clarity in interpreting these laws. These sections would impose additional standards which will create unnecessary confusion because state law currently provides comprehensive regulation of conflicts of interest. Sections 3.203 and 3.207 are not needed. Thank you.
Thank you.
Hello, my name is David Mihai, and I'm a member of the San Francisco chapter of Represent Us. A lot of talk has been made about the cultural nature of what the city is known for, of how its nonprofits are essential to its function, how we have a great culture of nonprofits in the city. However, there's a greater culture that overrides a lot of what people think of the city, a lot of how people interact with the city. And I think it's best summed up in this quote from the FBI probe looking into the matters in 2014 with Mayor Lee. We are the best at this game, better than New York. We do it a little more sophisticated than the New Yorkers. We do it without the mafia. The corruption in San Francisco is the biggest narrative that I personally deal with the city, with all my conversations with all the people I know regarding the city and how they're so disappointed and disillusioned about being unable to do anything without having to go outside of city government. These nonprofits are essential to the city because the city is unable to provide these services in the first place because of the nature of pay-to-play politics that is endemic to San Francisco. And it's a little shameful at times when I have to explain to people what I do. I can't even say that we are making progress towards getting rid of money in politics in San Francisco because we've lost progress. The natural human tendency to assume that progress is being made doesn't apply to this city. We're trying to reinstate Prop J, which we had, and we lost. We lost those guiding principles. They were already gutted. We're just trying to make up for lost ground. In regards to the behested payments, we have a list of what was shown earlier, the payments made since April 2015. The largest ones that I saw were Salesforce for $720,000, Sean Parker for $1 million, Peter Thiel for $1 million, Mark Benioff for $1.1 million, Ron Conway for $1 million, and Salesforce again for $1.7 million. And those are individual behested payments. I don't have the aggregate numbers. The nature of this city and what people think of this city and how they're so disillusioned and feel as if they're unable to participate in city politics because they feel like their impact doesn't matter because they'll be outspent is the greatest emotion, not only in the United States, but especially here in San Francisco. Especially when we're trying to catch up to Los Angeles, which already has a lot of these provisions on the books. They've been tested. They have judicial precedent for these being able to be upheld. I'd just like to see a city where I can look at the city government and how it functions, not just at the nonprofits and what people have to do to cope with the problems of city government, and be able to say that San Francisco is something I'm proud of. The city of San Francisco's government is something I'm proud of. Thank you.
Thank you.
Good evening, Commissioners. My name is Ace, and better known as Ace on the Case. I may not know it. I've been around a long time. I remember Mr. Welch and a few of those other gentlemen back there when I just got into the game. What I mean, the game politics. But I came under a great group back then, the only black group that was very forceful in my community in the Western Addition was called WAPAC, the Western Addition Project Area Committee. When I took on those characteristics as my political or community venture got on. So what I've learned from just the way back, and even some of those leaders were corrupt back then. First of all, let me go back to, we're here in the city by the bay, where everybody thinks everything's okay. But one day they're going to listen to what Ace had to say, because, you know, even though I wasn't around, wasn't involved with no nonprofits, most of my work was volunteer. And what Willie Brown had, when I did an interview with him, he talked about public housing people. He said something that I never forget. He said, sweat equity. And we're going to induce that into the public housing. But I looked at that and I said, damn, if that's the case, over 20-something years, Ace Washington, even if you calculate it at $50,000 a year, I got a lot of sweat equity that I never drew from. But then I also, using as a premise, that I don't see too many black nonprofits. And I'm going to study into that to find out, why isn't there any black nonprofits that these nonprofits say they service the indigenous people and the poor people? But in this city by the bay, where they think everything's okay, people like me who stand up here, there's a few people back there, African black, I can't see any black nonprofits to even mention. But there is one that I'm going to bring back to this Access Commission that I've been talking about, and it has to do with executive director that was appointed by Ed Lee in a position with the Human Rights Commission, which he was once the executive director. And that's where I met Ed Lee years ago. He knows me. We worked together when he was the HRC. And it's no mystery if you ask Ed Lee about me now, you know what he might say? He'll say, oh, Ace just working on some damn conspiracy. Well, yes, I am. About the black population. I know this is not the arena, but I thought I will inject that in there because I see all these nonprofits talking about the poor and all the people they take care of. If I told a story on what I seen in the 20, 30 years I've been dealing with politics and what the nonprofits supposed to do for us. But anyway, I got a couple more seconds to say. I'm just saying I'm getting a good education from here. Trust me, I'm getting a good education. And I thank God for this commission to bringing up these kind of issues.
Thank you.
Good evening, Commissioners. Elena Schmidt with Friends of Ethics. Just 3 quick comments. First is I just have to thank the commissioners and the staff for what has gone into the piece of work in front of us. It's obviously gone through a great deal of thought. I appreciate that, and it comes through very clearly. Appreciate the IP meetings that you've had. You've tried to get public input. You certainly got a lot tonight, and I appreciate the willingness of everybody to hear that. The second thing is I just want clarification on the issue that Commissioner Keene put forward about the private right of action. You seemed by the end of that particular discussion to think that there was 2 options in front of you, but I think that there were actually 3. And I think that there was what was Prop J, what was the staff proposal, and what was the LA ordinance. And I think that Commissioner Keene put forward the LA ordinance, and I just would like that clarified before you vote. The final thing is I understand the passion that goes into both sides of or all the sides of the arguments about the behested payments. Can you get the language right that protects the small nonprofits from the enormous amount of money that goes into behested payments? I would just note that when we did, I believe it was the Prop C issue, and we had questions then about a particular phrase and how was it going to be interpreted, that the way it was solved at that point was that we went forward with the general language that you all voted on, and then the Ethics Commission put out some facts, the frequently asked questions, that clarified what was included and what was not included. And then there may be some kind of compromise or some kind of clarity that can be brought at that point, because trying to get language that's going to cover everything that we want covered and that the nonprofits want covered is going to be very difficult. mainly, thanks for the work. Thank you.
Thank you.
You want to clarify
Yeah,
that?
I do want to, as I said when I originally put the motion together, it's the LA ordinance that we have as part of the framework of of what we're voting on. So, commissioners, is there anything further any members of the commission would like?
Yes, Commissioner Keene. As I've listened to all of this and I've been spending time reading some of this language, and I've got to say, I understood behested payments is a payment made for a legislative, government, or charitable purpose made at the behest of a city elected officer or candidate. That's the definition of behested payment.
Exactly.
That, as I understand it, in layman's language, it means if some elected official goes to somebody and says, I want you to make a payment to this charitable organization, that's a behested payment, correct?
That is correct.
But then I get down to your section on prohibitions. It says, no person who contracts with the city so-and-so, 1, shall make any behested payment or contribution to an individual holding a city-elected office. That isn't a behested payment.
That's, again, I think that's the wrong version.
Well, oh, okay.
Mike, please.
Give me the language of what it says. I was trying to save paper, but I obviously shouldn't. Didn't print.
So the language as it stands right now, says no person.
A section, so I can read too.
Page 21 of Agenda Item 5, it is section 1.126B. No person who contracts with the City and County of San Francisco, lines 3 and 4, skip to line 6, shall do any of the following if the contract has a total anticipated or actual value of $100,000 or more. Skip to sub 2, make any behested payment at the behest of a individual holding city elective office if the contract must be approved by such individual.
But that's not a behested payment.
Yeah.
Because your definition is it's got to be a payment being made to some other organization, not to an elected official.
It's at the behest of the elected official.
No, it says. But if the mayor asks you, say, I want you to make a contribution to Joe Blow, who's running for Board of Supervisors, that's not a behested payment, and that's covered by another section.
That's.
Am I correct? That's not a behested payment.
Make a contribution under B1.
That is a prohibited contribution under B1. So you can get a behest can be made for a political contribution, but we're talking specifically only the legislative, governmental, or charitable purpose.
Doesn't have to be limited to charities.
Pardon me?
Doesn't have to be limited to charities. It's a donation.
Well, but you've got a specific provision in the code that says that an elected official can't solicit contributions for other elected officials. Isn't that correct? In other words, a city employee can't go and what did we held the sheriff's office had a question. I mean, not the sheriff's, the district attorney's office, where they held a fundraiser for the district attorney. And can one city official solicit funds for another?
So I'm not sure if we're going a little bit far afield here, but there's an existing political activity prohibition that prohibits city officers' employees from soliciting campaign contributions from other city officers' employees.
Right.
But that, I don't believe, would be a behested payment, because behested payments are not campaign contributions.
Right.
Usually they are, as you already mentioned, they are charitable contributions, such as a donation to a 501c3, for example.
ahead.
If you have anything further, please, hopefully we've addressed.
Commissioners?
I have a question about where we are, just generally where we are. There's been references to Prop J into the Los Angeles ordinance, and so which sections are we to incorporate if this vote passes? So
You're to incorporate in regard to the definition of what is prohibited, and not just land use in regard to land use and contract matters, but also if you go to where the heck is it now? I said it to begin with.
but so that's from the original Prop J proposal that you submitted?
Yes.
Okay.
Yeah. We in addition to that, we also have the original Prop J, persons who receive a public benefit and the definitions of that and the people who are involved in that.
Okay.
So that's one. The second was that we specifically adopt the LA definition relating to the
Private right of action.
private right of action.
Oh, that's the LA version.
Yes.
Okay.
And the third thing was the Los Angeles law on commissioner fundraising. Those are the three things that are in there. That would be added to section 3.231.
But in the commissioner fundraising is minus department heads, which will be done on a different tract.
Right.
Okay.
Mr. Chairman, I have a question now with respect to the second point, the second issue, and that is, does it include the airport, fire department, unified school district benefits? I don't know.
I think if you're asking whether those would be included in the definition of a public benefit or incorporated in the public benefit, we don't have that language in front of us, so I don't have an answer for you.
Chair Keen.
Well, I want to be sure that that's included.
To go back to the top of the conversation, I believe
Commissioner Chu.
Chair Keen, you had included a request to expand the definition of public benefit.
I'm sorry, I missed
So
that.
at the top of the meeting, several hours ago now, you had requested, one of your 3 points was to expand the definition of public benefit.
Not to expand the definition of public
I'm sorry,
benefit.
to expand the
To-
prohibitions included in public benefit.
Prohibitions included in public benefit, yes, right.
Yes. So from my own standpoint, I think what would be very helpful for me, and also given the very detailed and prolific comment that we heard tonight from the public, I would like to suggest that we come back next month with all of these provisions in black and white in writing in front of us so that we can see exactly what is in the ordinance, because for my own sake, is it the LA proposition or the Prop J, just to be very, very clear. And also I'd like to suggest that the community and more interested persons meetings be held in order to try and work through this behested payments issue. Because I am concerned that there will be confusion and that there could be a chilling effect on nonprofits, and I don't want there to be a dragnet effect in our attempt to do the right thing in terms of getting rid of corruption and pay to play. And if there's a way to thread the needle, I think that we'd be well served in taking the time to try and do that.
Well, I think procedurally, we have on the table the motion to adopt this tonight, this being the Prop J that we've put forth, along with the specific aspects of the pay-to-play, the Los Angeles Commission fundraising aspect of it, the public benefit definitions, and the
Private.
private right private right. So we have that on the table. That's the matter before the commission. Essentially, I would think that what you are, Commissioner Chu, what you're putting forth is a motion to either table this or continue it to the next meeting. So we'd have to deal with that. Do we want to table it or continue it to the next meeting, or do we want to go ahead and vote on it at this juncture, having constructed what we have constructed? Is that a fair statement of where we are?
Yes,
right
and
now?
I would say that I would support Commissioner Chu's position. I think the fact that it is raised by some of the public comments that they didn't have the paper in front of them, whether they're right or wrong about it. But I would guess I would feel more comfortable if we had a finished product with incorporating the suggestions that you've made and put it up on the September meeting.
Okay, so we have the motion by Commissioner Chu to table this and continue it to...
Continue,
Excuse me, not to table it. That's wrong. You're right. Thank you, Commissioner Kopp. To continue this to the next meeting. It's been seconded by Commissioner Rennie. Any discussion on the matter of continuing it?
I'll support the motion, although I'm prepared to vote for the proposed, I'll call it Agenda Item 5 as amended tonight. They're all sensible provisions. And I also want to note, again, that the staff has had 6 interested party meetings, and let nobody say with believability that there hasn't been sufficient notice to members of the public who are interested in the subject. We've gone beyond the minimal required by law. And anyway, I've heard some misstatements here that I guess are part of the rhetoric of closing argument, Mr. Chairman.
Thank you, Commissioner Kopp. I want to echo what Commissioner Kopp has said. In my opinion, we're ready to vote on this. This thing we've had it before us since March. We've revisited it 3 times officially here. We've had a number of interested persons meeting. We know what the language is. The language, as we framed it tonight, even though we don't have it in one particular passage, it's like any other kind of legislation that we put forth. Someone puts something forward, and we do some amending, and we tinker with it, and we come out with the final version. We have that. And I'll, out of respect for Commissioner Chu and Commissioner Rennie, I'll also support the motion. But I think we're ready to go on this, to vote it up or down, and that there's been enormous effort done on the part of the staff and the part of everyone else. The public has been heard numerous times in public meetings. So the idea that somehow we're springing something on people and that they haven't had a chance to speak to it, that's bogus, in my opinion. And we should go forward with it. An enormous effort has been put in to attempt to address the corruption in San Francisco and to put back in what historically had existed with Proposition J. We're ready to go there. 2 commissioners feel that we're not. As Commissioner Kopp, I'll honor that, and since that is that's the motion, and it seems to be the sense of the commission, hearing no objection to that, then we'll go ahead and continue it to next time. I'm sorry? Public comment. Okay, let's have public comment.
If it's the will of the commission to push this over to September, the Friends of Ethics and the people that we worked with will be happy to work with the staff and with people in the community. I didn't have a chance to say that the draft that came from Friends of Ethics to the staff to begin with was written largely by the Campaign Legal Center in Washington, which, as you know, is now headed by the man who was in charge of the Federal Ethics Office and resigned over Trump. It was also written with the help of Common Cause and with the help of MapLight and Represent Us and other good government organizations, each of whom vetted it, each of whom were involved in the behested payments question. I think it would be worthwhile in the IP meeting for staff to do a one-page fact sheet on what constitutes a behest payment, because that has been the issue of some confusion. But if you took a look at the list of people who made behest payments, they are all people who have businesses before the city with decisions that are being made by the officials. 84% of the requests came from Mayor Lee. $4 million of it went to Mayor Lee's office for his purposes. So you can go right through it, and if to the whole list of things, and you'll see that there is a direct connection between people seeking a city approval and at the same time responding to the official who's going to approve that with the request that they give money. And the amount of money they give, as you've seen, can be up to $1 million. And that's only from April of 2015. If you go prior to that, it's considerably more. And in some cases, just to make clear that we're talking about nonprofits, you have an example of the mayor asking the Municipal Executive Association, which is made up of the city's management leadership, to give $5,000 to Spur, so that Spur could then give awards to the city's top managers. It's a pretty closed circle. That's the way it works. If you talk about other kinds of nonprofits, Spur is a nonprofit. It's a 501c3, and it is one of the places where people can give money. Thank you.
Yeah, let me just say, apropos of that, there was an answer to my question of the woman from the Glide Foundation as to whether they endorse candidates for supervisor or mayor anymore, and she says no, but we do with ballot measures. Of course they do.
I want to pick up on one thing that Mr. Bush said in regard to the input that's gone into this. And the input that's gone into this has come from some of the most reputable, thoughtful ethics institutions around the country. The Brennan Center, for example, which has endorsed this and said this is a great model. Other types of institutions whose whole basis is good government, no corruption in government. They've looked at this and they've endorsed it as well, and we've adopted aspects of it. So it's a commendable measure, and it should go forward. But anyway, Mr. Cohen, I'm sorry.
Just wanted to speak to the continuance, and I appreciate you taking the extra time. And no one who came here this evening, and there were 15 speakers who represent the nonprofit perspective, two things. No one was claiming that they were caught off guard. This is not a last-minute complaint,
One person
a
did.
Hail Mary.
One person did.
From the folks
not
that
you,
we
but
organized to
someone
come
else.
out here did not come out here to claim that this should be continued because they weren't noticed. We have been working on this since it was first introduced. We've been working on it dutifully. We appreciate the time with staff, the IP meetings, the hearings. So I want to clarify that that is not the basis of the requests for accommodation. Secondly, no one here has suggested that the organizations who've worked on this ordinance are not of reputation or don't have good models. Whether it's Represent Us, who we've talked with, or anyone else in this room or other organization, that's fantastic. All that said does not make a perfect ordinance. I've worked on a lot of public policy, and I'm sure a lot of you have worked on a lot more than I have. Just because we think it's good doesn't mean that it is entirely good. And that is the whole purpose of getting feedback. And you have a very professional community who has been very clear on one very specific issue. So we're not here to somehow disparage this ordinance as a whole. We have a particular issue which we think is not resolved, that we think is not right, and we do think that it's a good thing that you're taking the time to roll it over to give us a chance to get it right together with you. And thank you, Commissioners Chu and Rennie, for making that suggestion. The time that it will take to fix this is well worth avoiding the kind of controversy and forcing us in the nonprofit community to have to oppose, which otherwise, I agree, is a pretty darn good and well-needed ordinance. Thank you.
Thank you.
Commissioners, again, I just wanted to alert you to a complaint that I filed that has been subsequently resolved at the FPPC, and it had to do with the fact that a person did, in fact, donate a desk made of glass and chrome to an elected official, basically at their request. So somebody said, I'd like to have a new desk, and the new desks arrive based on the specifications of the person who received the gift. So if you do anything on behested payments, you might want to put in a clear-cut prohibition, because the FPPC ruled that they would dismiss the complaint for not having an appropriate basis of some type, some kind of a loophole, but I was pretty upset. I do want to close with one funny postscript, and that is this. When George Washington wrote his will, he announced or he put in a provision for the freeing of his slaves upon the death of his wife, Martha. So Martha, after George died, promptly quit eating her soup for fear that one of her slaves would poison the soup. And she obviously, to resolve starvation, basically freed her slaves. So even George Washington isn't perfect.
Commissioners, Debbie Lerman again from the Human Services Network, also want to express appreciation for just having a few more weeks to try to get this right. And we do hope that having that extension doesn't just mean we're going to wait another month and then pass it as written, but that there will be an opportunity to go over the very serious issues that have been raised tonight. You yourselves have stated on the record tonight that the plain language of the ordinance is not what you intended it to be. So we want to work with you. We want to keep working with staff and continue working with Friends of Ethics and Representatives and other advocates and just get this right before it goes over to the Board of Supervisors, so that ideally we would have something we could all support. There's been new provisions introduced tonight that are not in writing that we would also like to review and comment on and have questions about, and a couple of other points that we were not able to even discuss tonight because of the very short amount of time that we had for public comment on this issue. I just want to say that our nonprofit organizations, again, under federal law, we cannot and we do not get involved in electoral campaigns for candidates, but we do work on ballot measures, as is our right, and we do that in accordance with the missions of our organizations, that we get involved in issues that affect our organizations, our city, and the people that we serve, and we are proud of our work in that area, and that is not the subject of this ordinance in any way. And lastly, I just want to say, I think about some years ago, we had a nonprofit contracting task force in San Francisco, and one of the recommendations of that task force was to get rid of unnecessary requirements. Basically, every time some organization anywhere did something wrong, whatever it was, there would be a new rule adopted. And that rule would stay in place for decades until the point came along where no one could even remember why it's there. And basically what we have is this issue of over-regulation and red tape because of a couple of small incidents falls on everybody in order to try to comply with a regulatory scheme. So we ask you not to engage in overkill. Don't kill the golden goose that provides our nonprofits with the support that they need for services. Just because you might be able to isolate a couple of small instances of corruption that may or may not be coming from our sector. And frankly, we haven't heard the examples where our sector is the problem. So please don't impose these restrictions on all of our 501c3s because of problems here and there with a 501c4 or other types of situations. Please keep an open mind for our nonprofits. Thank you.
Thank you. Well, I guess we'll vote. We should vote on continuing the matter to the next meeting. Vice Chair Chu.
Aye.
Commissioner Rennie.
Yes.
Commissioner Kopp.
Aye.
And I vote aye as well. All right, so the matter is continued to the next meeting. We'll take a 10-minute break, and then we'll come back into the rest of the agenda.
SF.gov.tv. San Francisco Government Television.
Pardon me. Discussion and possible action on proposed ordinance to amend the campaign and governmental conduct code to disqualify members of city boards and commissions who have not filed their Form 700s from participating in or voting on certain matters. Kyle, go forward with that.
Can you turn on my mic again, Jessica? All right. So again, at its May 22, 2017 meeting, the commission requested that staff research and provide a draft ordinance that would restrict the ability, as Chair Keene said, of certain board and commission members from voting on substantive matters if they fail to timely file their Form 700. Again, we don't have to get into every specific unless you would like me to about this, but the idea that a board member or commission member could sit on a body and not have turned in their statement of economic interest disclosure and then vote on a matter and not have us or the public or anyone to be able to review the required financial interests seems to be a bit of a gap in the conflict of interest code, that they would be able to sit and vote on a matter where they could have a conflict. But the thing is, we just wouldn't know until some period after the fact that it had already occurred. If you turn to page, what is agenda item 6, page 3, you see that just analyzing the annual SEC filings of 2013 through 17 broken down, you see that in the cases here, although we have gotten a little better through education, I believe, over time from 2013 to 2017, you've had at least double-digit instances of this occurring where these officials have sat and then after or been appointed, been notified, given 30 days, and have still not turned in those statements of economic interest. Yeah.
I have a question. So what is the definition of a city officer? So who are these people exactly?
It's board members, commission members, department heads. It's effectively anyone in disclosure category 1, I believe, is how it's termed in the FPPC. Oh, sorry, I've gone too far. We'll get clarification.
Yeah, actually, just to clarify the chart. So are the people here, these are folks who would be filing directly with the Ethics Commission, that's correct?
That is correct.
Okay, so that would include department heads, elected officials, members of boards and commissions.
Question, Mr. Chairman.
Commissioner Kopp.
I know we won't invite public comment, but I'm ready to move this. But I've got some language changes, and I don't want to take time to go through them. It's words, and I'll give them to you, Mr. Chairman. But I have one substantive question, and that is on page 3 of the ordinance, subsection 2, exceptions, which allows a offending member to vote on general public comment. I don't know what that means. There's no vote on general public comment. I mean, participate and listen to it, I guess.
Perhaps.
Secondly, meeting minutes and the selection of a chair or vice chair. My question is why? Why should there be exceptions?
First of all, perhaps the end statement should be an or statement to clarify the sitting on, participating in general public comment. But I think when we was talking about this at the last commission meeting, is that at the commission's request, after hearing several public commenters, that they believe that there was certain non-substantive items that they should be able to participate in because there was no, or it was very limited, the potential for their conflict to affect them, whereas if their inability then to not...
All right, well, I don't accept that theory. I'd take out the exceptions. They either participate or they don't. I'd move that, well, go ahead, we need public comment.
How much of it would you strike? Just the
I'd strike the whole thing.
Well, I suppose the reason you might want to keep that in, not the language or general public comment, but, or meeting minutes, which are just approving minutes, is sort of the procedural. If they need a number of votes to elect a chair or some procedural matter, I would think
correct.
you wouldn't bar him or her from doing that.
That's correct.
It's so basic, and it's been in existence so long,
Right.
Commissioner Rennie, that I don't understand why anybody who holds a public office is required to file the statement of economic interest, doesn't understand it, and I don't think should be given the opportunity to vote for a chair or vice chair. Or the minutes, I don't know, there might be something substantive in minutes of meetings that might be relevant to litigation, who knows? Litigation is the most likely.
Well, I certainly wouldn't complain if it went out. So if you want to make a motion.
Well, let's hear the public comment, and then I'll make the motion.
Okay, sure.
Charlie Marsteller again for the record. I'm on this exceptions business. They could actually be elected chair or vice chair. You never know how mercurial some of these commissions can be. So that would be a bit of an embarrassment for the law, I would think, and show poor crafting. So I agree with Mr. Kopp. I think that's a good provision to strike. There was an article in today's paper, the Examiner, I would call your attention to. That should be distributed to the commission by the staff. There was a contract let by MTA to a person that's under...
I'm going to talk about that later.
Federal indictment. Okay, I didn't want to jump the gun on anything.
Commissioners, Larry Bush from Friends of Ethics. I wanted to comment on section 3.1-102.5, which calls for a warning letter to go out 30 days after someone misses the deadline. And then if there's no action on that, if I read the second part, 30 days after that, a letter goes to the appointing authority saying you should consider removing this person. So in effect, you've just added 2 months to the period of time when someone's supposed to file.
Mm-hmm.
Generally speaking, we send out alerts to people who file in advance of the April 1st filing deadline. I can say that because I'm one who has to file as a member of the CGOBOC. And so I urge that you not have a warning letter at a 30-day period and then another 30-day period for the appointing authority. They either file on time or they're unable to vote, period.
Any further public comment?
I'll move to, huh? Oh,
My name is Nancy Cross, and I'm here not necessarily to give an answer to any of the problems, but to maybe add complication in an area that is very much related, but seems to have been off limits for your commission, where you talk about the public beneficiaries, and you have land use decisions and so forth down there. What about the homeless? If they have a bed to sleep in, is not a public benefit? And can it be subject to the same kind of bribery? And it actually is. And it's a place for collecting money and stealing and no remedy. The remedies they have are fraud, such as the city attorney has found out in terms of the financial institutions that required people to waive their court rights in order to have the arbitrators decide for the banks and the financial institutions 99.9%, I believe, of decisions. And that in order to do business with them, and here is somebody, here are the people that are trying to do business with the city to try to have a bed at night, and the threat of losing your bed unless you cooperate with the corruption. And the response in the shelters, when you report the stealing, well, we're not responsible from the nonprofits. And we need a forum that looks for the requirement of a just cause, or probable cause, before people are denied their benefits. But they're being denied their benefits and denied any remedy that represents trying to get a factual determination and a fair determination. And then you can pay a bribe so that you don't have to suffer it. Now, this you've worked on these complicated things, so I'm sure you won't be overwhelmed with my effort to bring the same kind of thinking and reasoning and behavior of people to keep up the crookedness. And I'm looking for a fair administrative hearing in lieu of one of these fake arbitrations, and trying to get the city attorney and mayor into having a remedy available to the thousands of people who are homeless, who are caught in this internet and on the streets and suffer injustice, and certainly stimulated to criminal activity because there isn't anything readily available. And we'd like your cooperation in our effort to be considered subject to doing something about the corruption in the homeless area, rather than having people that are not ignorant of this think, well, the homeless we can't think about that. We think about real things, not the homeless. The homeless are suffering the same thing, and the price is very high, that you're going to lose your bed that you have been acquired. And things are done by computer overnight. When somebody wins, you might say, a bed spot, and then the next morning they're told, we don't have you in our computer system anymore, because we can alter what a computer says and give the bed to somebody else. So I would like you to add your list of public beneficiaries, the homeless, and that they're not getting what they're due by the same kinds of corrupt things, but somewhat riskier. It's not just whether you have a piece of land or a building, but whether you have a life to live when you have no place to sleep.
Thank you.
You're welcome.
Commissioner Kopp, I think you have a motion.
Yeah, I'd move to delete that subsection 2.
And you're moving that we vote for the ordinance with that deletion?
Right.
Okay, is there a second?
I'll second it.
Seconded. Any public comment? Okay, hearing none, we'll go ahead and vote. Commissioner Chu?
Aye.
Commissioner Rennie?
Aye.
Commissioner Kopp?
Aye.
And I vote aye as well. It passes unanimously. Okay,
Now you got the ordinance as amended.
which one?
Same one, as amended. We haven't voted on that. I'll move the ordinance as approved.
Yeah,
as-
you're right,
as
you're
am-
right. That's the
As
amendment, okay.
amended.
And, okay,
Andrew,
in regard to
give this to Leanne.
a motion on the ordinance as amended, is there a second?
I'll second it.
All right. Any public comment? So we'll call the roll on that. Commissioner Chu?
Aye.
Commissioner Rennie?
Aye.
Commissioner Kopp?
Aye.
And I vote aye. The ordinance as amended passes unanimously. Okay, the next is, where are we? What's our next item? Seven, okay, I'm sorry, I lost track. Item 7, discussion and possible action on overview of staff's preliminary proposals to strengthen commission enforcement regulations. Ms. Bloom.
Thank you, Chair. Since about August of 2016, when I started, we've been undertaking a pretty comprehensive review of our enforcement processes, the regulations, and basically the way we interact with other agencies within the city and in order to carry out our mission of effective enforcement with as much accountability and transparency as possible. We've implemented some changes along the way. One I'll discuss in my enforcement report. Another is the investigation and parallel proceedings investigation policy. And then I've been continually working on our relationship with other agencies sort of in the background, and reviewing civil grand jury reports from the past several years that identified a number of inefficiencies in our enforcement processes, particularly on the accountability and transparency realm of policy issues that one might have with an enforcement process. I've come up with several conceptual changes, or we've come up with several conceptual changes to the enforcement regulations. This is a preview of what's to come. We have a draft set of regulations that are circulating now internally for review. I've also distributed that draft set to some enforcement directors at the other ethics commissions to get their review before we release a comprehensive set for public comment during interested persons meetings in September. But today I just want to give you a highlight. The first major change is to put the conduct of investigations under the purview of the enforcement director, who is also the deputy director, so that would be me. After a preliminary review, I would have the authority to open investigations and conduct them independently. The executive director would not have any involvement in the day-to-day conduct of investigations in order to free her up as a independent arbiter of subpoenas and whether subpoenas are appropriate and narrowly tailored, because she has, as executive director, she has subpoena authority. And then in line with our second recommendation, she would be able, well, actually in line with current regulations, she makes probable cause determinations. And so as the person conducting the investigation, it would be better and more it would give her an opportunity for more independence and of judgment if she did not conduct the investigation, if she's going to make a probable cause determination. Right now, she only makes probable cause she makes determinations to not find probable cause, which leads to the second major substantive recommendation, which would be to also give the executive director delegated authority to make decisions to find probable cause. Under the current enforcement regulations, which implement the charter, the commission as a full panel makes findings of probable cause. Our reading of the charter does not require that the commission make the finding. Our reading of the charter indicates that the commission could delegate that authority to the executive director so that the full panel of the commission can retain its independence of judgment for the hearing on the merits or consideration of the final disposition document in the form of a stipulated settlement agreement. So the executive director in this scenario would make a formal finding of probable cause after a probable cause conference. That's an informal hearing where the rules of evidence wouldn't apply, basically in our offices at 25 Van Ness. Her finding of probable cause would become a probable cause determination that would form the basis of a charging document that would then come before this commission in a full hearing on the merits. And that brings us to the third substantive change, which is the elimination of the accusation document as a duplicative document that currently serves as the charging document. So under our current process, the commission makes a finding of, the full panel of the commission makes a finding of probable cause, and then staff has to issue an accusation document that is public. There's really no reason for that duplication. The accusation is currently required to be issued within 10 days of the finding of probable cause, so there's no substantive difference between the two. So we might as well just eliminate that accusation and allow the charging document to be the finding of probable cause, and that would be the document that the respondents are required to respond to before you on the hearing on the merits. Some other changes that we'd propose making and that you'll see in coming drafts are that the stipulations that we enter into would be considered in public rather than in closed session as they are now. The charter only requires that investigations be kept confidential through a finding of probable cause, but stipulations are negotiated with respondents on the mutual agreement that probable cause exists, such that something is there to settle. So there's no reason that the stipulation itself needs to be considered in closed session. So we would agendize stipulations, and then you would consider them in public, with the public being able to comment and give their input on the propriety and appropriateness of the agreement. This makes staff more accountable, and it helps bring transparency and ensure public confidence in the commission's decision to adopt a stipulated order, because it wasn't done in private. We also propose, so as you know, the Sunshine Ordinance and regulations are currently in a separate document from the enforcement regulations. I understand that there was a very important reason for doing that historically, but substantively, I think that if we're going to rewrite the enforcement regulations, we could merge those two documents so that there's not a duplicative document that identifies a separate procedure that really doesn't differ that much from our normal investigations process, while retaining the very different procedure that exists for certain types of complaints, but just within the context of the enforcement regulations. So I know it's a little bit confusing, but right now under the Sunshine Ordinance regulations that we use to handle those investigations, there are two tracks. One track could easily be assimilated into our regular enforcement process. The other track could easily just be carved out and placed into our enforcement regulations. So there's not two competing documents that are difficult to find. Basically, the public has a hard time finding and differentiating between the two. And then another provision that we would like to adopt, this is something that we take directly from the FPPC, is the ability of the commission to enter default orders. Right now, the commission doesn't have the authority to enter an order against a respondent unless the respondent appears. This would give the commission authority to enter orders against respondents if staff can prove they are properly notified and that the respondent failed to appear due to their own failure. And then finally, our late filing fees process has existed by policy, and we would like to incorporate it into a regulation so that the public has an opportunity to comment on it, and so that it is public and for public consumption and not hidden, buried in some policy. Late filing fee policy involves a couple of things. The first is that filings that fall on weekends and holidays late filing fees of $25 per day would not start accruing until the next business day, because staff's not in the office anyway, so we already just waived those filing fees. So we want to make that in law. And then for the waiver policy, we would propose adopting the waiver policy by regulation, making some substantive changes to it, which we'll bring forward, and you'll be able to examine in our next iteration of this document. So I previewed the stakeholder engagement plan for September. We'll host two interested persons meetings in September, bring back a draft document for everyone to review in September, including the public and the commissioners. If appropriate, host additional interested persons meetings depending on the comment that we get at the September meeting. And then there's a provision of city law that requires regulatory changes to be noticed for 3 weeks. So that would push our ability we would publish a final set of regulations in October, but not vote on them until November. So that is the plan. And I'm welcoming any questions or feedback.
Yes, Commissioner Chu.
Ms. Bloom, can you talk a little bit about the consent calendar that you've identified in Section 4 and how that works with hearing stipulated orders in open session?
Yes. So at the FPPC and in Los Angeles, they've adopted what's called a consent calendar. And that allows the staff to place on a proposed calendar of consent, unanimous consent, that certain stipulations below a certain threshold. So at the FPPC, it's, I think, $10,000. So if the settlement is for less than $10,000, the settlement will go on a consent calendar. And then, like the information that you get now, within 5 days of the meeting, you would get a copy of the consent calendar and all the stipulated agreements, and you would have the opportunity to review them and pull from the consent calendar any issue you had with the below $10,000 threshold stipulations for discussion at the following commission meeting. And if you did not pull from the consent calendar, they would just appear on the consent calendar as already agreed to documents for the public to review in advance of the meeting. That gives the public, the agreement is already agreed to, so we can't like revoke our agreement at that point, but the public would have an opportunity to publicly discuss the agreement at that next meeting. So every stipulation would appear on an agenda before the commission, rather than how they are now negotiated in closed session and then published the following day.
Wait, so, but at the end of the very last sentence in section 4 says, absent a request for a hearing by commission, members of the public will not have an opportunity to provide public comment and debate regarding each proposed stipulated order that's on the consent calendar.
Right, they would not on each one. So the consent, because the consent calendar will be an agenda item, we have to give public comment on the agenda item. So, but they wouldn't have an opportunity to give a public comment on each stipulated order on the consent calendar. So it would operate, the consent, this is how the FPPC does it. It says they have like agenda item 7, consent calendar, and then it'll list 7 or 8 stipulations for settlements below the $10,000 threshold. And then the public has an opportunity to provide comment on the appropriateness or their views on those 7 items as one public comment period under the Brown Act instead of 7.
Okay. Thank you.
Commissioner Rennie.
Did you contemplate that the executive director, in her determination as to probable cause, that the complainant and the respondent would appear before the executive director and make their case as it may be?
Yes, absolutely. The process of finding probable cause won't differ very much, other than the executive director will make the decision, the determination, I should say. So we would still have a probable cause report that goes to the executive director, and then the respondent would have an opportunity to file their report, and then there would be a rebuttal or reply. And then the executive director would retain authority to ask for more information if needed in order to, before she makes her final decision. You know, if you kind of think about it as like a magistrate judge,
right,
making the probable cause finding before the full panel of the commission, so the judges can retain their independence on the subject matter.
That's such a big improvement over what we have now, where we have as a probable cause hearing, we have this whole secret trial. In terms of that kind of due process, one doesn't even get that in the criminal justice system, where someone's life and freedom is at stake. You have a magistrate making a determination of probable cause. So I think to put it in the context in which the executive director makes that determination, then we go on to do a full hearing as to whether or not there is indeed a violation or not. That makes ultimate sense.
Mm-hmm.
Mm-hmm. I thought all the suggestions are
excellent.
good suggestions.
They'll certainly tighten up and help us to make our enforcement mechanism much more efficient than they have been in the past. They've been dreadful in the past.
Yeah, in researching the probable cause determination process, I looked at the FPPC's Organic Act, the Political Reform Act, and it also references, so both the charter says that the commission must make a finding of probable cause, but it's like a lowercase c, and so that small c is the same commission that is used throughout the charter section on investigations enforcement, Appendix C, to give the executive director authority to do all kinds of things, to conduct the investigations, issue subpoenas, et cetera. And under the Political Reform Act, the provision giving the staff authority to conduct investigation also uses a little c, and the FPPC regulations are where the commission delegates power to their executive director and enforcement director. So we're sort of modeling our process on an existing process and an existing model at the state level that I think will work for us.
Great. Any public comment on the matter? Okay, hearing none, we'll then go to item number, is it 8 or 9? Eight. Okay. Discussion of enforcement report and update on various programmatic and operational highlights of the enforcement program's activities since the last monthly meeting and their attachments.
Yes, thank you. Me again. So this month the last 2 months we've been very busy. We received 16 new complaints since our June meeting. After completing a preliminary review, we opened 8 investigations and we requested the dismissal of 25 complaints, which the subject of which is part of the second portion of this memo. But about 120 complaints remain in preliminary review as of August 17th. That number actually ticked up to 121 because we received a complaint yesterday. And attachment 1 contains details about those matters in preliminary review, but we're slowly getting through all of the older matters and really focusing on our attention on getting through those as quickly as possible and making important judgment calls that need to be made about what merits further investigation and what simply needs to be dismissed. In August, we also closed 3 investigations after finding no probable cause existed. Those determinations were made by the executive director, and you received those determinations in advance of this meeting. And then we referred 2 cases to outside agencies for investigation. Attachment 2 contains additional information about those open investigations. So going forward, as you notice, we have 25 complaints that are proposed dismissals awaiting the executive director's review, and in sort of realizing the workflow that is inherent to having all of the dismissals come to the commission meeting at the same time as all of these memoranda, we've realized that it would be advantageous to everyone, including the commissioners, if we could provide those dismissal summaries at a different time of the month. And so starting in September, we're going to start providing you the monthly dismissal summaries on the 15th of the month for you to review and digest, so that when you get your materials for the end of the month meeting, you've had time to look at the vastness of all that documentation, which really amounts to hundreds and hundreds of pages per month. This will help improve our ability to manage workflow, and we hope it improves your ability to manage workflow.
Commissioners? Any public comment? Okay. Agenda item 9, discussion of the executive director's report and update of various programmatic and operational highlights of Ethics Commission staff activities since the last monthly meeting.
Good evening, Commissioners. I will keep this brief with the lateness of the hour, as I say, but I did want to make a couple of announcements. First is that with the budget that is now in place, we've been able to move forward on some newly authorized positions, and I'm very delighted to be able to share with you news that Gayatri Teikendil will become our Chief Programs Officer, overseeing an expanded education, engagement, and compliance group effective September the 9th. As you know, Gayatri has been serving and will be serving through September, the first week of September, as our executive fellow, and has been doing a really tremendous job helping us think through and develop new ways to reach out and engage the public and others with information they need to comply with the law and understand the laws that we have. So I'm very excited about that. We look forward to having Gayatri, who is here with us tonight still, having her meet with you and present information to you as the months come along, but we're very excited about that change. I also wanted to introduce to you Pat Ford, who is our new policy analyst. He's been quiet tonight, but he has been the other half of Kyle Kundert's brain trust to bring forward these policy memoranda. So Pat's joined us on July 3rd. Also Jeffrey Zumwalt, that you'll have a chance to meet at some point as our new investigator. We have also importantly been using the time, the downtime, as it were, from last month's commission meeting break to really put in place all of our staff performance plans for the coming year so that individual plans and goals are linked directly to the overarching goals that we've been talking about through our budget over the last year and a half. So we've put those individualized performance plans in place, and we've had discussions with that. We're finishing that up in the next couple of days. We also did an all-staff meeting for 2 days to review subject matter, content, operational and internal workflows so that we can try and move our work to the next level of success over the coming year. Lastly, we are continuing to work on our hiring. We have about 6 or 7 positions still in play. We have 2 positions that closed recently and are moving into the qualification review and selection process. So we'll continue to keep moving forward on that, and I hope to have more news for you at the September meeting and my report at that point. I'm happy to answer any questions if you might have them.
Commissioners? Is there any public comment? I'm sorry. Commissioner Chu.
I just want to congratulate staff on closing out all of the 2012 audits.
Thank you. I'll relay that.
Terrific.
Any public comment on this agenda item? Okay, and then we go to item 10, discussion and possible action regarding status of complaints received or initiated by the Ethics Commission. Is there a need for any closed session? Hearing none. Is there any comment on any of the status of the complaints?
No.
Any public comment? Okay. So we'll then go to item 11, discussion and possible action on items for future meetings. Commissioner Kopp.
I want to ask staff and refer to it. The matter Mr. Marsteller started to discuss, and it's encapsulated in Larry Bush's email to members of Friends of Ethics about someone by the name of Durf Butler, who has been indicted and is being prosecuted by the United States Attorney, indicted last April on charges of bid rigging in federal contracts, and also was one of the people on tapes from the Federal Bureau of Investigation in the so-called Shrimp Boy case. Anyways, on bail, but he was just awarded, what, a $1,600,000 contract by the Metropolitan Transportation Authority, which, as a friend of mine used to say, was a nice piece of business. And as Mr. Bush, it's covered in a story in the San Francisco Examiner today, which anybody on the commission who's interested can read. But Mr. Bush points out that federal law allows for a so-called denial of participation of individuals in similar circumstances with respect to federal contracts, and prohibits such transactions for a period of time, which can be followed by actual debarment. I would like the staff also to research that federal law and give us a memorandum and report at the September meeting, first on whether any of our charter, ordinance, or regulations apply to the MTA award of such contract, and then secondly, depending upon the result of that, whether the federal law should be iterated in our law in some manner, a recommendation on that. And then secondly, just for everybody's information, I know members of the commission will be interested, members of the public too. The Sacramento County Superior Court today issued a decision in a lawsuit in which I am a co-plaintiff against the governor of California and the state of California, striking down a law enacted last year which permits general law cities, of which there are about 465 in California, to enact public financing ordinances. And the ground of the court's decision and the basis of the suit was that there is a prohibition as a result of a 1998 ballot measure against public financing in general law cities. A bill was introduced in a fashion which would submitted that repeal desire to the voters of California probably last November, but instead the legislature and governor ignored the rule of law, deleted the ballot measure clause. Governor signed it, and today Sacramento Superior Court reminded the defendants of that notion of the rule of law, which I guess leaves the proponents with the choice of appealing to the Court of Appeal or doing it properly and getting a bill next year which submits the question to voters in June of 2018. I'm sure Common Cause is well aware of today's decision. Thank you, Mr. Chairman.
Thank you, Commissioner Kopp, and congratulations on your success as a litigant. Is there any public comment on this agenda item? Speaking of Common Cause.
Yes, Common Cause. Actually, I support Mr. Kopp in his position on this matter. I had urged Common Cause wholeheartedly to talk to him a good while ago before they considered going to the ballot. I will say, to the legislature, saying that I think they better clear it first. But I do want to thank the league for basically handling themselves on this matter rather well. They did join in the legislative process, but they were not as insistent on this matter as Common Cause was, unfortunately. And I've seen this type of mistake before, but I'm glad that it was litigated, and I think that I wasn't at all surprised with the outcome. And I think they'll do the right thing now. But I did want to say that was 1988. Not 1998, and that
88.
88.
Yeah.
Yeah, Props 68 and 73. I remember it well. I was supporting Prop 68. You were on Prop 73, as I recall.
Any further public comment? Okay. Item 12, additional opportunity for public comment on matters appearing or not appearing on the agenda. Any further public comment on anything? If not, we'll entertain a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
We're adjourned.